The Supreme Court of the State of Colorado is now in session. Chief Justice Coates presiding.
Thank you. Please be seated. The first case we have on our docket this morning is Hindsdale County Board of Equalization and Board of Assessment Appeals versus Ausherman. I got that right? So it looks like we have two petitioners in this case. Is there an agreement with regard to time, or what were you all planning? All right, then we'll let you all keep track of your time and split it in the way, but I'll look for you to do that. Okay, both counsel look like they're ready then. Let's petitioners go forward.
Good morning. May I please the court? My name is Michael O'Loughlin of Schumacher and O'Loughlin LLC. I serve as a Hindsdale County attorney, and I'm here appearing on behalf of the Hindsdale County Board of Equalization. I'm joined by Krista Mayer of the Colorado Attorney General's Office, who's here on behalf of the Colorado Board of Assessment Appeals. Essentially, the issue this morning is whether restrictive covenants attached to a real property interest may serve to transfer tax liability from the record title owner of those property interests to the Common Interest Community Association that manages the property and enforces those covenants. The simple answer to that question is no, because Colorado statutory scheme clearly provides that taxation shall be assessed to the record title owners, and it makes no difference that the real property interest is qualified or limited by covenants.
So I've got to jump in right away.
Yes,
Good morning. Is that really the issue that we're facing, that this is just a restrictive covenant, or is the question really who has the incidence of ownership? I mean, I with respect, I'm concerned that I know we granted cert on the question, but as I've now read everything, it didn't seem to be an accurate assessment of the issue. The Court of Appeals said, as I understood it, the club retained all the incidents of ownership. We look to substance, not form. Therefore, their actual owner is the club. Isn't that the issue we're really dealing with?
Sure, I think if you want to characterize it like that, yes, that's the interest. So jumping right into that. So the court, rather than following the statutory scheme, used the substance over form doctrine in this case to state that the substance of the property rights is with the association or the club rather than the individual owners. Typically, substance over form doctrine in Colorado is used to address who the proper party is for taxation when there's some sort of exemption that may apply. So a court or the BAA or the BOE would be forced to look at the benefits and the burdens of the property interest to decide who the rightful property is and whether a tax exemption should apply. The Court of Appeals extended that doctrine to a new area of law to cover common interest associations and covenants. It's never been extended that far before. So this is a new rule extended by the court, which I'd argue that is in breach of the statutory scheme. However, even if you want to use the substance over form doctrine, what it says is, it does a benefits and burdens analysis and says who has the right to possession, use, enjoyment, and profits from the property. Now, the court used the form of the bylaws and the covenants to discern that the club and not the owners enjoy all those benefits. But what the record clearly shows is the right to possession, use, enjoyments, and even profits in this case is with the owners and not the club. It's hard to fathom how a club would enjoy the benefits of hunting and fishing, enjoyment of a piece of property. The club is essentially set up by the developer for the use and enjoyment of the owners that purchase a property interest in the club.
Is it accurate that the club gets to decide who uses what ranch when and who's on what property when?
Well, there are cross easements across the entire property, which were part of the recorded covenants. So no, basically when people or owners arrive at the club, they check in and check out. There's not some hardline club that's there. Basically, they check in and check out, they use the club, they register.
Do they use their own
guests.
property?
Yes, they may use their own property.
You said may. Do they have the right to be on their own plot of land with their own ranch?
Yes. Then they
Okay.
also have the right to be on other people's ranches. That is exactly what they bargained for when buying into this property.
Can you think of any other area where you own real property, but you can be on anybody else's property, anytime, and somebody can exclude you from your own property?
Well, there's another club similar to that in Gunnison County called the Savoya Club. It's in the record that when Respondent Ish was considering the purchase of property interest in the Lake Fork Club, he was also looking at that club. But I think you're getting to a different question into whether a common interest community association has the right to restrict an owner from its own lot or unit. And that's a different question for the court, and one that's not here today. And whether that specific covenant is enforceable or not, I think is an unsettled question under Colorado law.
And I appreciate your bearing with me, Mr. Laughlin. And the reason I asked is the Court of Appeals found that fairly significant, that the club could eject an owner or exclude an owner from his or her own property at any time.
So
Is that not right?
well, there's no evidence in the record that that's actually occurred. The club is using the general covenant that says they can, restrict an owner's rights to use the club or their benefits, I think is what the bylaw says, in the event an owner is delinquent in the payment of their assessments. There's no actual evidence in the record that that has ever occurred here to the respondents or anybody else at the club. Basically, what the court did is took the form of the bylaws, and I'm going into the substance over form doctrine, which I think was improperly applied, but if you believe it is applicable in this case, you would take a look at the form of the bylaws, covenants, rules, and regulations, and determine whether that form controls or whether the actual substance of the rights on the ground control. In this case, we have extensive testimony from the respondents that they bought in purposefully to camp and hunt and fish on this entire property, and this is what they bargained for, this is what they wanted. And now they're using those same rules as a basis and reason to transfer tax liability from themselves to the club, which simply shouldn't be allowed because the club is a simple management agency. It doesn't own a real property interest.
So what's the real property interest we're talking about? So they bought a deed for this square of land, but they could use the whole club, and it's just kind of a placeholder? I mean, you see what I'm struggling with? I mean, this is just a very unusual situation, I think.
These are unique covenants, but it doesn't change the fact that is what they are, which are restrictive covenants that were recorded in of record prior to the respondents and all the other owners buying into the club. This is what the developer wanted to do. There's nothing under Colorado law that says a developer can't put covenants on a property or cross easements in this case to allow people to use the entire property. Now, it makes sense why he set it up like this, because rather than just getting a membership like you would at a golf course or something else, you have a deeded fee simple real property interest, meaning you can buy and sell it as you wish. So the club has no right to revoke that interest or rescind it, similar to a license, other than if they would have the right to foreclose based on HOA lien foreclosure, but that's a separate issue. So.
One last question then, and I'm sorry, I'm struggling with this. I think it's a hard case. It seems like then you buy your little square of land, let's make it up, 1 square acre, but you buy the right to use the entire property. That feels more like all the owners would be tenants in common of the whole. I mean, I'm just trying to see how do we get to the place where the assessor gets to tax the 1 square acre when that's not really what you own?
That is really what you own for real property purposes, because that's how the developer set it up and subdivided the property into separate parcels. The developer could have created a tenant in common situation and sold off fractional interests of the property to create a tenant in common situation if that's what he wanted to do. That's not what, or We Country Corporation in this case, so that's not what they intended to do. They intended to set up fee simple interest, which is clear, that's stated in the declaration. So that, that's the developer's right. There's nothing to preclude them from setting up a club in this fashion.
Great. Sorry to take so much of your time. Thank you.
Yeah. Okay, so going back to what the statutes say in this case, and my initial point is that the substance over form doctrine was misplaced because it was extended to common interest community associations and covenants, whereby that's not the intent of that rule. And in this case, statutory law is absolutely clear that the assessor has a duty to ascertain tax ownership from the real property records. It also, the statutory scheme says it makes no difference that the use, possession, or ownership of that taxable interest is qualified or limited. In this case, the qualifications or limitations are by and through these protective covenants, okay? The next applicable statute, 39.5-104, says that each parcel of land, and this is another direction to a county assessor, shall be separately appraised and valued. Now, in this case, the developers divided the property into 29 parcels. The assessor has the assessor must, if they're following statute, assess and value each parcel. What the Court of Appeals did is they said, well, we don't care what the developer did. We don't care what this statute says. We think that the assessor should assess the entire 1,400-acre property as a whole and give it to the HOA rather than the record title owners. That's new law that's created by the Court of Appeals in this case. That's never been done before. This is a common interest community, subdivided parcels, separate record, 29 separate parcels with various record title owners. Statutes are clear. You send those bills to the record title owner.
Mr. O'Loughlin, can I interrupt you?
Yes, ma'am.
So your opponent argues that this is not a common interest community, in part because there's no individual ownership of land that involves a right to exclude, and that in order to have a common interest community, you have to have common property that's appurtenant to individually owned property on which you have a right to exclude. How do you respond to that argument?
So each individual owner has their lot interest, and what the Common Interest Community Ownership Act says is that if you, by buying into a community, if you have to pay for assessments for the maintenance of property outside of your interest, i.e. common property, that means it's a common interest community, and also alludes to payments of your own insurance, so on and so forth. In this case, the bylaws in the last section mandate for each individual owner to pay for their own liability insurance. So
you don't think the right to exclude is as important as they seem to think it is?
Well, again, like I was mentioning to Justice Gabriel, I think that would be a separate question for the court, and whether it's legal for a common interest community association to say that, not the exclusion point, I think that's what they bought into, but whether you can say if you don't pay your assessments, whether you can't go on your individual lot. Okay. So that's a different question, which I don't think is settled. Typically in common interest communities, an HOA excludes you from common area and not your own individual unit. So that's a separate question. That's not before the court today. And I question whether that specific rule would be enforceable, but we're looking at a more global question today, and whether the instance of these restrictive covenants changes record title ownership for taxation. And the Colorado Common Interest Ownership Act is clear that it does not. And the Court of Appeals, I think you saw in the briefs from both parties, erred by finding that the applicable provision of Kiowa doesn't apply to this case when in fact it clearly does. So I'd like to talk briefly about the implications of the Court of Appeals decision. And
Before you do that, Mr. Laughlin, you're talking about the law. Could you address the 39.1.115, the prima facie evidence piece?
Sure. So prima facie evidence, with that law, in my understanding of when it's used is, so it's true that record title doesn't always tell you who the true owner is. And what comes to mind when that may be the case is in an adverse possession case. When, as you all may be aware, when adverse possession, the statute says it'll date back to the date when the 18-year time frame ran, even though the adverse possessor has not perfected that title by and through obtaining a quiet title action and then recording the court order that would formally quiet title. So in that case, the quiet title order would then date back to the date that the adverse possession exists. And there's actually rules in the adverse possession statute for payment of back owed taxes to the party that lost the property interest. So, and it also is used in the context of this case when, a government entity holds record title, and then when the substance over form doctrine is traditionally applied, that, the taxation could go to a lessee or concessionaire that's basically using the entire property, even though it doesn't hold record title. So I don't think, it's never been applied in the context of a common interest community association holding record title. They simply don't hold record title.
Thank you.
Okay. So implications briefly of this opinion statewide are, it's going to be very difficult for assessors, courts, the Board of Equalization, Board of Assessment Appeals to apply this decision because they're left with a rule that says you have to consider covenants when you're deciding who the record title owner is and decide if those covenants are so onerous that the tax liability should transfer to the common interest community association from the record title owner. However, the court didn't provide any criteria or other basis in order to how, why, when, if to make that decision. This is going to lead to a lot of additional real property appeals in the state of Colorado because you're basically giving a new, I'll call it a tax exemption, even though it's a tax transfer, to a whole group of people. And it's also going to increase workload and costs of county assessors statewide. But more importantly, I think, is how this is going to affect the tax lien process in Colorado.
Can I actually, sorry, when you said it's not a tax exemption, it's a tax transfer problem, one of the things that sort of, so as a practical matter, the county will get the same amount of real estate tax, whether it's paid by the HOA or by the individual owners?
Well, maybe. Now, in the context of this decision, I don't think it would, because the court is basically saying this is one 1,400-acre parcel versus 29 separate parcels. In valuation methodology, typically a larger parcel is valued to a lower amount than separate subdivided parcels. So, and also I think in terms of the tax, so that's one issue that no, not in the context of this case, but maybe yes. But due to the increased litigation that's certain to occur in this opinion, this is going to, especially a small county like the one I represent, this is very difficult for us to handle, the costs involved in these appeals generally, let alone opening up a whole new avenue of appeal that's not provided by statute. I assume if this opinion's held up that you'll see an influx of these cases moving forward.
What language in the opinion do you point to that you think suggests that the Court of Appeals was announcing this very broad rule or shift in approach, and not just tethered to the very unique facts of this unique club situation?
Well, it's hard to tell. I mean, they tried to say that, but I don't know why, what would hold back a litigant from using it to their advantage and trying to transfer tax liability from themselves to the Common Interest Community Association. It seems to me that this would be a new tax exemption providing property owners with a basis to appeal, regardless whether you're a hunting or fishing club or some other common interest community that you as a property owner would deem the covenants to be onerous for whatever reason.
Can the ranch owners change the covenants, and how hard is it for them to do that, and what relevance does that have to the analysis, if any?
Well, that's extremely relevant because they had notice of these covenants prior to their purchase, and they can, by a 67% vote threshold, change the covenants.
I thought it was 75%.
By statute, that's under Kiowa, that 75% threshold drops to 67%. Okay. I believe it's subsection 217 of Kiowa. So yes, they can change it at any time. They can change the bylaws at any time.
But part of your point is that they don't want to change the covenants, right? They all want to be able to go hunt and fish on the whole 1,400 acres. They just don't want to pay taxes for that.
That's what the record suggests, that they bought into this for this purpose, and now they're using those same covenants as a basis to transfer or avoid tax liability.
I know you're trying to get to your colleague here. The rule you're asking us to adopt, would you want us to say the substance over form doctrine never applies in a common interest ownership community?
I don't think it should. I don't know if it's necessary to go that far in this case. I think in this case, even if you apply the substance over form doctrine, it's clear the substance is with the parties. The club is a nonprofit corporation. Despite the court's reliance on 40-year-old bylaws and covenants, the fact of the matter is there are no profits on the property for the club. Any and all profits realized from the real property interests are from sales of the parcels. The court did not address how their opinion can be reconciled with that fact. They left it out of their analysis, which I found surprising.
And last question for me, I promise. You distinguish Mesa Verde in cases like that on the grounds it was government-owned property. Could you help me understand why would the substance over form apply only in favor of the government, but not in favor of someone else? You can argue this case is exactly the converse of Mesa Verde.
I guess in the context of covenants, you would have to adopt or really think hard about specific rules and criteria to put in there, and how, when, why, if a covenant would serve to transfer for tax liability. And also with the government tax exemption, that's a creature of our Constitution and statutory law. There is no underlying basis here for transferring real property interest to a covenant manager and enforcer.
Thanks.
So one more quick point, and then I'll get to my colleague here, is that this complicates the tax lien process hugely in the state of Colorado, because basically, in practice, what the Court of Appeals opinion means is that the record title owner has no legal duty or onus to pay the real property tax bill, and that the Common Interest Community Association should pay that tax bill. But you must ask yourself the question, why would the Common Interest Community Association pay that tax bill? They don't own anything. They have nothing to lose. So basically, if the HOA says, we're not paying it, you go to tax lien sale, and you go through the tax lien process, and the record title owner could lose that property interest with having no legal duty to pay for the tax bill in the first place. It would essentially create a complete mess of the tax lien process in Colorado. So I'd like to get to my colleague here if no further questions.
Right.
Thank you.
Thank you.
Good morning. May it please the court. My name is Krista Mayer, registration number 42140 with the Colorado Attorney General's Office, and I represent the Board of Assessment Appeals in this matter. The Court of Appeals opinion below bent the law to fit this unique set of facts, and this court should reverse for two reasons. First, the title owners, and not the club, are the true owners of the ranches under Colorado law. And second, the covenants did not deprive them of their ownership or their tax liability. I'd like to start off by addressing the covenants. Agreeing to the covenants was itself an exercise of the rights the title owners acquired when they purchased the ranches. The covenants allowed the title owners to agree collectively to use their property as an open space hunting and fishing ground. In this case, the title owners benefited from the covenants because they allowed the title owners to use the entire 1,400-acre subdivision for hunting, fishing, camping, and other activities. And contrary to the title owners' arguments, and this goes to some of the questions that Justice Gabriel was asking, I did not find any language in the covenants saying that the club could or would prevent the owners from accessing their own ranches, or that the club decides when the owners can or cannot visit the subdivision. There was also no evidence in the record that the club ever actually enforced the covenants in such a restrictive way. And that's not to say that there could never be a covenant that was overly restrictive. But in that case, the remedy would address the covenant itself. For example, the covenant could be amended, or it could be deemed invalid and unenforceable. The remedy for an overly restrictive covenant should not be to take away ownership from a real property owner or to take away his or her obligation to pay property taxes. A decision that the title owners do not own their ranches would also damage the reliability of Colorado's recording system. In the past, courts have recognized that our race notice recording system is the linchpin of Colorado real estate law. Recording a deed gives constructive notice of the conveyance of real property to subsequent buyers and provides certainty and predictability in our real estate system by allowing buyers and lenders to determine exactly what they are acquiring. And our recording system also publicly identifies owners of real property for other purposes, such as judgment liens. This court should also reject the title owner's argument that the club owns the ranches In addition to not holding record title, the club does not have, for example, any independent right to sell the parcels, bring guests onto the subdivision, build residences, or exclusively occupy the subdivision. And the club does not make a profit on the assessments and fees it collects. It's a nonprofit corporation that exists for the purpose of managing and maintaining the subdivision. Any assessments the club collects are used to improve and maintain the property. And the covenants empower the owners to amend or even terminate the covenants altogether. If they did terminate the covenants, the title owners would still own their real property parcels, and the club would not have any rights to the property at all. So to conclude, the opinion below bent the law because it applied a substance over form analysis in a context where it has never been applied and in a way that was contrary to Colorado law and policy. It removed ownership entirely from the record title owners despite the fact that they purchased their parcels through valid deeds. It concluded that the club owned the ranches even without a valid deed or other incidents of ownership.
Can I direct you to the question that Justice Gabriel asked your co-counsel, which was about the government exempt cases and why the form over substance or substance over form rule might apply there, but not in this case?
Well, so in those cases, there are different laws and policies at play. So as my colleague mentioned, the Colorado Constitution prohibits taxing government-owned property. However, there's a tension between that law and policy and our strong presumption in Colorado against tax exemptions. And so when you have a private possessory interest in an otherwise tax-exempt government-owned property, the court has to apply a unique analysis in those situations.
Did Mesa Verde actually talk about that at all, these policy reasons? I don't remember it doing so. It just applied substance over form, and I may be misremembering. So I hear the argument you just made. I'm just curious if we said that in Mesa Verde.
The
The Mesa Verde case was the one with the concessionaire in the Mesa Verde, park. And I don't remember the focus being on the policy in favor of government entities, because government entities, there were restrictions.
Is it in favor of government entities or in favor of taxation?
Well, that's the tension that I'm talking about. Okay, so Article 10, Section 4 of the Colorado Constitution prohibits taxing government-owned property. However, there is also this presumption in Colorado against freely or liberal application of tax exemptions. And so in Mesa Verde and some of these other cases, the analysis was applied in a situation where a private entity was basically had all of the incidents of ownership except for the record title and profited off of that ownership of a possessory interest in the property. And so to that extent, yes, in Mesa Verde, they were discussing that. They may not have used the exact words that I used here, but those were the policies at play there. And so to reserve just a little bit of time for rebuttal, I'd like to conclude by asking this court to reverse the Court of Appeals below. Thank you.
Counsel?
Hey, good morning. May it please the court, my name is Michael J. Russell, and I'm an attorney representing the original protesters in this matter, and my number is 16313. What's been left out of the discussion to this point is the converse of what we're talking about as to the club, because all the discussion has been about the club and their control over the property through the covenants, the bylaws, and the rules and regulations. And that's all accurate. The club does control the entire 1,400 acres, the 3 miles of river, to the exclusion of any one individual. And there was lots of testimony at the court of, or at the hearing that, in fact, club members don't even know where the property lines exist. They buy a 1/3 interest in one of these ranch parcels, but may not ever even travel onto their property. The entire property is left in a 1,400-acre ranch property. And the club controls that to the exclusion of everything. The restrictive covenants here are restricting all use. They are not like a Kiowa covenant where you have the color of your house may be a different color, or the size of the setback, or the fence that is created in the backyard has to be a certain height. Those are the kinds of use restrictions we see in a homeowners association typically. This, on the other hand, it covers everything. They control everything. They control, as the Court of Appeals said, exclusive hunting and fishing rights, exclusive right to construct and maintain over and across the ranches, all the utilities, roads, lakes, ditches, bridges, fences. And in fact, there was testimony at the hearing that they had just recently redone part of the river bed to the tune of $100,000, which would be an assessment against the members, and we're considering moving the entire river further away from the highway interior. Well, when they do that, they have affected those ranches, because when they move that, now they have river on a different location than it was before. The owners of those ranches are affected by that technically, but not practically. And so what I'm talking about, the converse to this issue, is what is it that those members, those owners buy when they buy that ranch, when they buy that 1/3 common interest ownership in that ranch? What are they buying? And the testimony from Mr. Ish was that he was contacted on a Saturday morning by Mr. Hall, who sold all of these properties back in that time frame. This is 1994. And he was told, I have one available. I have a 1/3 interest available. And come on up and see it. So he gets up there, and it happens to be ranch number 30. Ranch number 30 is on the far side of the highway, on a steep terrain, and it happens to have a shooting range on it that is operated by the club. So what Mr. Ish is looking at purchasing is a property that, even if he wanted to walk on the property, could get shot. I mean, he can't go on his own property without danger. And the fact is, that didn't mean a thing to him. It didn't matter, because what he was buying was a membership interest. What he was buying is a membership certificate in the club so that he could then participate in the club. So the value that he paid for that property was for that membership interest. Didn't have a darn thing to do with the real property interest.
But that's not how this was set up. I mean, your friends here make a persuasive argument, I think. They bought exactly what they were told they were going to get. They bought a real property interest that gave them all these rights with all these covenants that you were just talking about. Why isn't that, for purposes of real property tax, why isn't that right? They got exactly what they agreed to buy. A deed that gives them all these rights, and there's all these restrictions.
Yes, Your Honor. And the reason that it was important for them at that time, 1994, when Mr. Ish purchased his property, to have a real property interest was because they still had the ability at that point in time to put up to 3 residences on any given property. And so therefore, you needed to have a real property interest so that you could construct that residence. In 1999, the members all voted to put a restriction in that prohibited any residence. That changed the makeup of that organization dramatically on that date, because now you didn't have the ability to get anything other than a membership interest.
So are you saying that when Mr. Ish bought the land, it was a real property that he would pay property taxes on, but it ceased to become property that he owned by virtue of that covenant change?
Well, as you may be aware, the manual for real property and for the assessor's use says that in any given case, you can have a real property interest and a personal property interest that's acquired. And in fact, the example they use in the manual is a fishing membership, ironically enough. So when they purchased these for many years, and from the time Mr. Ish bought his, for the next 20 years, the assessor recognized that personal property interest and allocated 1/3 to the personal property interest and 2/3 to the real property interest, as is allowed under the manual. And so for many years, they recognized, yes, there is an allocation of a portion of this property being personal property and a portion being real property. And they gave them that allocation. In 2015, the assessor said, I'm not going to recognize that anymore. I'm just going to charge all these property owners 100%. And now in 2015, of course, you had absolute use restrictions. You couldn't even build a residence on the property. The allocation that was given to them up till 1999 probably should have been adjusted at that point in time, when actually you had much more, if not all, of the interest becoming a personal property interest. And that's what the Court of Appeals found, because the facts that the Court of Appeals was looking at was that all residences were prohibited from the property.
Why isn't that an issue of just the valuation of the property as opposed to who has to pay the tax? I mean, I'm just hearkening to Justice Hart's question. It sounds to me like your argument is not that the nature of the real property changed, it's now their rights changed, so the allocation should differ.
Well, in point of fact, the real issue there is what is the nature of the ownership? And in 1999, when that became completely a membership interest, I think is when it becomes much more analogous to the Roaring Fork case, where the taxing authority came in and said, in connection with this golf and hunting and fishing club, we believe that the membership agreement provides for a leasehold interest. And when you pay your $200,000 membership fee, that's actually a leasehold property interest. And so we can add it to the valuation, and you have to pay that full amount. And the court said, no, when we review it, that membership agreement is providing for a license. And it's really just a membership interest, and it gives you the right to use the property. And that's exactly what we have today in this case.
But you seem to have said, and again, I'm picking up on Justice Hart's question to you, and I'm not sure I heard your answer, that when the owners themselves agreed that to say no more building, no improvements on these lots, that it changed from a real property interest to a license. And I'm not quite sure why that would be.
No, I think that there was always an allocation of a personal property interest, whether you call it a license or a membership interest in the club. And that membership interest, by the way, was always an equity membership interest because you could sell it. And there's golf clubs all over the place that are nonprofit golf clubs that operate as nonprofits that have equity memberships that become valuable. You can sell them on the market, and that's exactly what you had here. These memberships became more valuable. The property didn't because you couldn't use it. And so, in point of fact, it's what is the nature of the interest that you're selling? What is the nature of the interest that you're holding? And when it became clear that what they're holding is simply a personal property interest, which is not taxable, that doesn't mean the tax goes away. It just means who becomes the proper taxpayer. And in this case, the proper taxpayer is the one that controls the entire property.
Mr. Russell,
The
can I ask
club.
good morning, can I ask a factual question? Do different parcels have different values? Like you're talking about Mr. Ish's property that's on a steep hill. Is that valued at less, or all of these valued evenly?
Well, and to your point, there happens to be 30 ranches. Ranch number 27 doesn't have any real property attached to it whatsoever. It was originally held by the developers, and they didn't put any real property to it. And
Is this the floating membership? that you're-
in
Okay.
membership, yes, it is.
But what about
And-
the ranches that do have real property attached to them? Are they, the 26 ranches, are they of different value, or are they all the same?
Well, that depends on who you ask. If you sell your interest on the open market, they all have essentially the same value, regardless of
The
where they're
assessor's
located.
valuation.
Now, the assessor in 2015 adopted a valuation, yes, that took into account where they were located, how close they were to the river, the terrain on the property, the size of the property, and did a discounting methodology to the valuation. So yes, indeed,
But
as of-
before 2015, were they all assessed at the same amount? You said in 2015 they.
In 2015 and I can't answer that question, to be honest with you. I don't know prior to that, when they were doing the 1/3, 2/3 allocation, how they came up with their values. But from the member standpoint, including the floating membership, no matter where your parcel's located, they all have the same value. Because, again, what you're buying and selling there is a membership interest.
Except that if you, I'm sorry.
No, go ahead.
They don't necessarily have the same value. They may have the same value during the time that the members own the property, but when Mr. Ish goes to sell his property, he'll be able to sell it for one price, and someone with a larger amount of property within the ranch boundaries will be able to sell their property for a higher price.
No. That has not historically been the case. And in fact, as I was just making reference, the floating membership that doesn't have any property to it essentially sells for the same value as any other ranch property that's a 1/3 interest, no matter where it's located. And the reason for that is because what they're buying is the right to be a member in the club.
I'm sorry, I guess I didn't understand your answer. Are the properties assessed a different value? I didn't understand your discount answer, to be honest with you.
Yes. The properties by the assessor are through a discounting method assessed at different values. All
Thank
of
you.
the ranches, depending on where they're located and their size, are all at different values
Okay, thank you.
as of 2015.
Mr. Russell, I just invite you to shift gears a little bit and address the workability argument that opposing counsel, maybe you already have implicitly by emphasizing total control, but can you respond to counsel's argument that you're going to render this whole property tax scheme unworkable by, among other things, wreaking havoc with tax liens and all of that?
As is often pointed out in these kinds of cases where you're dealing with substance over form, they're almost always fact-specific because of the nature of those cases. You're dealing with a case that has unique set of facts, and this one certainly does. In addition to that, the statutory scheme doesn't change. The assessor can still go to the public record and still can send out notices of valuation to all the record owners. The assessor can, as they have for many years, go beyond that. We would have never had the Mesa Verde case if the assessor limited themselves to the public record, because the Mesa Verde company was not in the public record. So the assessor knew that that property was out there, that this was government land, and they actually went and sent them a tax notice. And that happens all the time. There's all kinds, assessors regularly go beyond the scope of what the public record is. But it doesn't change the basic scheme, and the prima facie evidence rule would still be in place, and it would be incumbent upon the individual owner, taxpayer, the one that receives the notice of valuation, to protest. And then when that person protests, they have to come up with an argument that is as unique as this property or a similar substance over form issue to be able to prevail. And so it doesn't change anything that the assessor has to do. The assessor's going to still follow their same procedures, and they're not going to have to go in and look at all the association's covenants.
So the answer to my question is it's a very small subset, and you have the rebuttable presumption. Can you respond to opposing counsel's argument about the rebuttable presumption, statutory provision really applying to adverse possession scenarios and things of that sort as opposed to this scenario?
Well, I've never seen anything that would limit it to that. I think his example is correct, that yes, in the area of adverse possession, it would apply. It would also apply in any of the, you see, there's another statute that says that if you believe that you've been erroneously taxed, then you can protest. So if you say that only record title owners would be able to, that would be an unrebuttable presumption, then that would negate the other statute that gives you the right to go in and make the protest and try to prove, in fact, that your property is not to be taxed and that somebody else is the owner for whatever reason. It could be for any of the myriad of reasons that we've talked about. It could be the assessor going in and trying to establish it. Just most of these cases on substance over form are coming from the taxing authority. It's the taxing authority going in and telling Vail Associates that they need to pay tax on the ski resort. It's the taxing authority in the Cantina Grill case that says that the concessionaires out of DIA have to pay tax. The substance over form policy actually benefits the taxing authority.
But all of those, pardon me, all of those, Vail Associates, Cantina Grill, Mesa Verde, all involve concessionaire-type situations where, at least to me, the connecting narrative thread there is the possessory interest in otherwise tax-exempt government property. And so in that situation where a private entity is occupying tax-exempt government land and operating some sort of business, the question is that possessory interest taxable? Right. And that's when we have employed this substance over form test. And it does strike me as unusual what the Court of Appeals did here by expanding that or applying that test in this very, very different context.
Well, the Roaring Fork case was not that situation where the taxing authority was coming in and trying to assert that there was value to the leasehold interest that was a membership interest in a golf club. So that is different. Also,
although I wouldn't say that Roaring Fork, I mean, here we have deeds, and the deeds reflect that the ranch owners have received specific parcels of property set out by meets and bounds, that they hold that property in fee simple. I don't think that was the situation with the golf memberships, right?
It wasn't at all.
Okay.
It was a membership agreement that they were looking at. But and I can't remember the name of the case right now, but where the court found that an assignment of development rights, I think it was Village Tree maybe, was a taxable interest, and that's not in that context either, but that's the substance. They're taking an assignment and they're saying it is. I know that in the Gunnison County case, you do end up with a tax exempt situation, but what they were looking at there was a lease, and a lease back where Gunnison County is going to end up owning the property at the end of the day, but they have transferred it to a for-profit entity, and the court was looking at, is that going to create a situation where we can tax the entity that's actually the record title holder in that case? And the opposite was concluded, that no, in the leaseback situation there, where the county actually was going to end up as the owner of the property, at the end of the day, they were handling all the construction of the project and were occupying the building, that the property was tax exempt. But I think it is the opposite situation, where you're actually looking at trying to tax the record title holder, who is in fact a for-profit company.
Mr. Russell, could I have you switch to the statutes, the plain language of the statute 395102 that talks about, for purposes of property taxation, it shall make no difference that the use, possession, or ownership of any taxable property is qualified, et cetera.
And your question is?
How do you respond to, what's your response to that applying to this situation?
Well, I'm going to have to look at it, because I'm sorry, I'm just not.
It's, for your assistance, it's 395102.
Oh, so you're talking about the same statute that they go to the record owner?
It's in Title 39, yeah. Right, and then 391106, I guess, is the one that talks about for purposes of property taxation. I apologize, 391106.
$39,106, you're saying?
Right. It's on page 26 of the
Oh,
Hindsdale.
partial interest not subject to separate tax. This is the unit assessment rule.
What's your argument with regard to that?
As far as the unit assessment rule goes, if the property is in fact all owned by the club for property tax purposes, there is no unit assessment rule issue whatsoever, because you're not, what the unit assessment rule says is basically, if you have an easement on the property and you have a leasehold on the property, then you tax the property as a whole, and you don't break out that leasehold and the easements. But if you have the property as a whole already being taxed, then the unit assessment rule isn't implicated in that.
So you're saying that that's not applicable in this?
It doesn't violate the unit assessment rule. What would violate the unit assessment rule is if you were to take all of these single property owners, 1/3 property interest owners, and send them all a separate tax bill, because technically there's only one ranch there. And the assessor's been doing that for years.
Can I
But-
ask about Kiowa too, just as we're talking about statutes? You say that Kiowa doesn't apply here, this isn't a common interest ownership?
Yeah, and I do know that the Court of Appeals said Kiowa didn't apply, and Kiowa obviously does apply because the statute specifically says that it applies. But for the same reasons that we're talking about here, that you essentially have property here where there's no boundaries and everybody can travel across everybody's property. It is all common. You don't have any units. And so, although Kiowa would apply, this is not a common interest community. You don't meet the definition of a common interest community that requires that you have separate units, and those units need to either be occupied or controlled. And under the restatement of servitudes, they talk about some kind of an exclusive type control. You have to be able to have a unit that you somehow control, and then apply that to the common areas. So when you pay your assessments, you're applying that to other property in the common interest community, which only makes sense. You have separate units, and then you have common interest property. And all the common interest property is paid for by those units. Here you don't have units, and you don't have separate property. It's all one. So I think if the Court of Appeals had looked at it, just based on what they did with all of the rest of it, would have come to the same conclusion. And also, one last point on to say that all of these folks enjoy the benefits of the club is absolutely true. They do. They enjoy those benefits as members of the club. And to say that they could change those at any given point in time is accurate. Anything can change. That's why we have 2-year assessments. I mean, you can have a vacant lot and build a house on it, and now it's a residential lot. So the assessor is bound to look at the situation in any given 2-year period. We can't speculate on what might happen in the future. I think Mesa Verde even made a comment about that point and said, just because it's a 31-year lease, we can't speculate on what they might do or change or how they might change it. But they all enjoy this as members, and they're members of that club, so their rights are to get on the board or to advocate the board to make any different change. That's an organization. That's not them individually. They can't make any change individually to their property.
But they could each sell their property, right? Do they have the right to sell their property?
They can sell that property, and again, the sale price for that property is going to reflect what people are willing to pay for a membership in that club, not what that real property value would be. The real property value, as was done by our appraiser, is a 1,400-acre piece of property. And that's how it needs to be valued. That's the comparables that need to be used in order to value it. And that would apply whether it were the individuals or the club that were the owner. We think it only makes sense, as the Court of Appeals ruled, that it is the owner is the club, because they control the entire 1,400 acres. But in any event, the property would have to, as a comparable, be valued against other comparable properties of 1,400-acre type ranch property.
Mr. Russell, I think your time is up now.
Thank you very much. I appreciate your time today. And in conclusion, I would just say the Court of Appeals got it right here. Thank you.
Thank you. Petitioners, you have a couple of minutes.
Quickly to address just a couple points on rebuttal here. It's obvious that the respondents don't like the covenants or have some issue with the covenants. This is the wrong venue and mechanism to change those covenants, as you heard. If they don't like the covenants, they can do it internally in their homeowners association, or if there's some legal issue with enforceability of a specific covenant, they're free to challenge that covenant in court. I'd also like to address what I term a legal fiction of a separate membership interest. There's no separate membership interest available on the open market. What you buy when you buy into the Lake Fork Club is a deeded parcel and real property, because that's what the developer set up. That's what's explicitly stated in the covenants in which you get, and that's what you get a deed. There's no other value here. It is a membership that's buying through a deeded real property interest, period. In the scenario that they're talking about, if there was some value on a separate membership, that membership would need to be available on the open market, and there would need to be some market for that separate membership. In this case, that's simply not the case. This is a deeded property interest, and with that deeded property interest, you get access to the club grounds. And I'd like to also address Justice Boatwright's questions earlier in terms of basically the assessor used comparable sales to come up with the values on these parcels. And it's my understanding from reviewing the record, and it's all in there, that the comps do show some sort of adjustments for size and the status of each lot. At the BAA, we had testimony from the state property tax administrator that aided our assessor in making those determinations, and his testimony is in the record as well, that he believed that the comps were appropriately valued pursuant to Colorado law. So I'd like to close just with the statement from the BAA on page 6 of its order, where it stated that, quote, each club member's unrestricted use of the club grounds as a whole is not a limitation, as the parcel owners attempt to portray, but is a benefit for which the parcel owners purposely bargained for in purchasing valuable property rights within the club's grounds. Now, it makes little sense at this point now to let those same reasons provide a basis for the respondents to avoid the tax liability, where Colorado statutes make clear that the tax burden is theirs to bear.
Thank you. I'd like to thank all counsel for their arguments. The case will stand submitted, and the court's going to take a 10-minute recess. Thank you. Please be seated. The next case on our docket this morning is called City of Golden versus Sodexo America. We've set this one for only 40 minutes, so 20 minutes per side. Everybody looks ready. Counsel for the petitioners, start when you're ready.
If I may. Thank you, and good morning. Matthew Munch, 42287 for the City of Golden. With permission of the court, I'd like to try to reserve myself a little bit of time, maybe 7 minutes for rebuttal, but I understand that's on me. What we're all doing here today is essentially Sodexo.
Is that like sort of like waving a red flag in front of a bull that people then will dominate all of your time and you won't get any rebuttal?
trying to be a little bit circumspect, but just I'll try to do my best, Your Honor.
Thank you.
Sodexo is a private for-profit company that is operating any number of franchises and dining halls on the Colorado School of Mines campus. They are claiming that these operations are somehow wholesale sales to the Colorado School of Mines itself rather than direct retail sales to students. Now, I should point out at the beginning, as such, because they are claiming they are wholesale sales, they are claiming that they are subject to a wholesale sales exemption, and therefore the burden is on them to prove entitlement to that exemption. However, this claim that these are wholesale sales, it really does fly in the face of the contract documents themselves that they have between Sodexo and Colorado School of Mines. It flies in the face of the on-the-ground reality of the transaction, and frankly, it flies in the face of common sense. And with permission of the court, I'd like to illustrate that a little bit. Now, the City of Golden is a home rule municipality. It has full authority to enact its own local sales taxes, and it has done so. As a form of tangible personal property, Golden has explicitly imposed a tax on all sales of food under Golden Municipal Code Section 3.03030. Now, a sale is also defined in the Golden Municipal Code as the acquisition for consideration of tangible personal property or taxable services. That's what defines the moment, the incident of a sale. The taxable event is the acquisition of that tangible personal property in the exchange of consideration. So if we look at where the acquisition takes place on the ground in reality, the Colorado School of Mines never actually acquires anything. All of these items are bought presumably at wholesale by Sodexo. Sodexo maintains control of them the entire time. Sodexo doesn't retransmit them in an unmodified state. Sodexo will take various ingredients, combine them, usually at the point of sale, sometimes to order from a student standing across from them, and give it over to that student, put it in their hands directly, without a Colorado School of Mines employee being anywhere near it. It is directly from Sodexo to the student. So obviously, it is the student who acquires the meal, and nobody really debates this. Sodexo's vice president of operations said as much when asked who is the ultimate consumer of these meals. The answer is the student, not the Colorado School of Mines.
Doesn't Sodexo argue that the School of Mines takes title to the food? Even though they don't take physical possession, they have title, they have the right to inspect, they have the right to reject.
Well, the right to inspect and right to object, certainly there is some mention of that in the contract, but as the court knows, what the standard we need to look at here is what is reflected in the on-the-ground reality. What is the actual nature of the transaction, not necessarily the refinement of title.
Sure, and I'm looking at that too, but you can certainly argue that it's not dispositive that the school doesn't actually take physical possession if they take title, and they can direct Sodexo to do whatever they want.
It may not necessarily be dispositive, Your Honor, but it is still a factor that I think weighs heavily in favor of the City of Golden. Another factor that should weigh heavily is if they're taking title of it, if this is in fact a real situation where the Colorado School of Mines is ordering something to be for wholesale, then the contract documents should put everybody on notice for exactly what it is that they're buying, how many quantities of it, where and when it's supposed to be delivered. None of that is in there. If the Colorado School of Mines, if this is a wholesale sale to Colorado School of Mines, how is it possible that Colorado School of Mines did not say, we want this much of these items at this time?
Is there not a price list in there? I mean, the contract has a price list that the school is going to pay to Sodexo.
But that price list is not specific. That price list is not per item. That price list is not saying, we want this many pounds of flour, we want this many pounds of strawberries, we want this. It's very broad, and same thing with the standards that Sodexo argues that they put in this contract. If you read them, they're very vague, they're very nebulous. It's supposed to be healthy, it's supposed to be, you're supposed to have certain options. Ultimately, it is Sodexo, without input from Colorado School of Mines, who is deciding what goes on day to day at these operations.
Why isn't it analogous to a requirements contract, where you kind of figure out at the end of the day what's required, but you have, you're going to meet all requirements, and here's the unit price? That would not make it a retail sale when you ultimately sell it, would it?
I don't believe that that is analogous to the contract document that you're looking at here. The contract document that you have here is titled, in fact, a contract for food services. It is explicitly at its title, and then throughout, it talks about how the purpose of this contract is to enable Sodexo to operate food service locations on the Colorado School of Mines campus. The word wholesale doesn't appear anywhere in that contract, and I briefed it all. It's a number of places in my brief, but there are any number of places where they talk about how the program allows students holding a meal plan to use one meal swipe at retail locations to purchase a complete meal, and how that it is the responsibility of Sodexo to essentially to sell these directly to students without any involvement by the Colorado School of Mines. So I would agree that it may not be necessarily dispositive that the Colorado School of Mines does not ever take possession of this or have any involvement in it, but it certainly is a factor that argues very heavily that the reality of this transaction is not one of wholesale sales. You combine that with the fact that the contract documents are utterly inconsistent with anything that would be reflective of wholesale sales. Combine that with the fact that, as I mentioned in my brief, nobody disputes that when I could go onto the Colorado School of Mines campus, I could go up to the dining hall, let alone one of the franchises, I think there's a Subway, any number of other things they operate, pull out my credit card and buy a meal. And that transaction would be, everybody agrees that that is a direct retail sale from Sodexo to me. Colorado School of Mines doesn't own that property, doesn't own those foodstuffs. That transaction would be utterly indistinguishable from a transaction to a student. In fact, it's pulled from the same group of materials, and that alone ought to disprove the idea that this is a wholesale sale, that there's a vat of soup in the back, and some of it can be sold at retail to me, which means Sodexo maintained control of that property the entire time. They owned it the entire time. And then a student can come back behind me. The person labeling out the soup doesn't know. They just swipe one card or another. And that this other volume of soup is somehow the wholesale possessed property of the Colorado School of Mines. So essentially that this property would have to be both at the same time, and it would only resolve itself as to who owned it going back to forever upon the point at which it was sold to the person. That doesn't make any sense. That alone should disprove the wholesale.
But the difference is there's no contract in the middle. I mean, the School of Mines never has anything to do with that, whereas here, the School of Mines has a contract with its students. Here's the meal plan, here are your choices. You, student, are going to pay me, School of Mines, X dollars. Then School of Mines has a separate contract with Sodexo. In that retail example, there's no middle person like that. It's a direct sale from Sodexo.
And yet it is utterly undistinguishable on the ground from the sale to a student. Now, there is a contract between the Colorado School of Mines and Sodexo, but that contract, as again, I don't want to take all day on this, but I've detailed in the briefs all the different ways in which that contract is wildly inconsistent with the wholesale sales contract. That contract is exactly what it purports to be, a contract for them to provide food service on the campus. As far as the contract between Colorado School of Mines and the students, yes, the Colorado School of Mines collects money from the students. That's what they do.
You want to say the contract is only as it makes them a collection agency, but it's hard to read this very lengthy contract as a collection agency contract, very different than was the Hodgson case, where it's a 10%, we get 10%. That's kind of what the contract says.
I don't necessarily agree that that's true.
All right, go ahead.
The contract, it does specifically provide for the school's responsibility for collecting payment from the students and then paying the successful officer Sodexo. That's in the request for proposal attachment A to the state contract, record page 991. It also talks about how, again, on the same document, page 992 of the record, The school will collect all board plan fees and then pay Sodexo. It also talks about specifically providing for Colorado School of Mines ability to retain amounts of money on top of what it pays Sodexo, which is exactly the way you would expect any collection agent to be compensated for their services. You would not expect them to do this for free. Combine that with all of the references in the record from the depositions from Colorado School of Mines employees talking about how one of the reasons they do this is to, I don't mean to imply any disparagement, but is to make money, is to drive revenue. They're a school. Margins are tight for everybody. They're tight for the city of Golden. They're tight for Colorado School of Mines. They're doing this at least partially to make money. And all of that, Your Honor, I would submit backs up rather than challenges the idea that they are acting as a collection agent very similar to the way it is laid out in Hodgson v. Profit Company.
Can I ask you a question just about the contract? And, you know, the way this contract is arranged, is there any possibility for the school to incur a risk of not being able to resell at retail something it has bought at wholesale?
Well, I don't think there would be any risk of that, Your Honor, because I don't agree that they have bought anything at wholesale. I think that...
You understand the nature of my question, meaning is there any difference between what the school would pay for, what the school would buy, and what it would sell? Is there any possibility of slippage between those two?
If I understand the question correctly, Your Honor, I apologize if I don't, but I think, if anything, that also backs up the idea that this is not a wholesale sale in the sense that the Colorado School of Mines, if there is excess, if there is waste, as there usually is with food operations, I am not aware that the Colorado School of Mines is required to keep control of that and dispose of it. I believe that ends up being some Sodexo's problem. And the fact that, again, that would evidence that this is not a wholesale sale to Colorado School of Mines. Colorado School of Mines doesn't take possession of the excess. Now, excess kind of loses all meaning when you factor in the idea that Colorado School of Mines has no idea how much of what items they're buying if this is a wholesale sale. The contract doesn't tell them. So if I understood the court's question correctly, the risk of excess and the responsibility for disposing of that excess is entirely on Sodexo. And therefore, again, it's clearly what it claims to be, a contract for food service and not a contract for wholesale sales or sales of any type.
If the School of Mines agreement with the students did not have a use it or lose it provision, the School of Mines would be at risk. If absent that provision, and it sold nothing, no student ever bought anything, the School of Mines still would pay for all the food that it anticipated buying, and it would be stuck. It would lose a lot of money.
Well, I believe the School of Mines would end up paying for, ends up compensating Sodexo for the meals provided.
Right, and it would buy them, but if it sold none, it would be stuck, except that it protects itself by telling the students when you buy the meal plan, it's use it or lose it.
I'm not...
Maybe I'm not being clear. I was picking up on Chief Justice Coates' question. I mean, there would be an economic risk to the School of Mines here, as the person in the middle buys whatever food it's expecting to sell and then sells nothing. But it protects itself. So in agreement with the students here's the meal plan. If you don't use it, you lose the money. And so it protected itself. That would tend to support a wholesale and then a retail transaction.
I'm not certain that I would agree, Your Honor.
Okay.
I think the fact that there is an expiration date on the balance put on the blaster card, I'm not certain how common it is, but I do know that in my life I have come into possession of gift cards that have an expiration date on them. And I may have put money on that gift card at some point or gotten it from my aunt or somebody who put money on it. And sales tax was not assessed when you put the money on the card. Sales tax is only assessed when that balance is redeemed. Same with the blaster card. And if I don't use that gift card within a certain amount of time, that money goes away and I'm just out. But of course, in that situation, there was no transaction, there was no acquisition, there was no consideration exchange, and therefore there would be no sales tax due either. I have about 6 minutes left. With the permission of the court, I'd like to reserve that for rebuttal. Thank you.
Thank you, Chief Justice Coates, and may it please the court. I'm Neil Pomerantz, bar number 24741, and with me is my partner, Mark Medina. We represent the respondent, Sodexo America. We believe this case can and should be resolved on the wholesale sale issue, which was the basis for the Court of Appeals ruling below. Colorado School of Mines, CSM, sells meals to its students under meal plan contracts that it executes with each student at the beginning of each semester, and it purchases the meals that it requires to fulfill those meal plan contracts from Sodexo under a separate state contract that it executes with Sodexo.
Maybe I could sort of turn my question around for you, and you could start there, given from the way you've said that. Is this contract arranged in such a way as the wholesale that you're talking about or characterizing could ever be more than what is sold at retail?
Let me see if I can respond by addressing it. I believe it goes to the question of risk of loss. Could there be something different between what the school sells to its students and what Sodexo sells to the school? The school absolutely incurs a risk of loss here. They have contractual obligations with respect to the student. The student is obligated to pay only the school. The school makes a decision in its absolute discretion whether it wants to allow a student to collect a meal even if the student hasn't paid, whether it wants to grant a refund to a student under whatever circumstances it deems appropriate. And so there are situations where the school determines to allow a student to collect a meal even though it hasn't been paid for the meal, and yet is still obligated to pay Sodexo for that meal. So there absolutely can be a disconnect between what the school purchases and pays for in its relationship with Sodexo and what it receives from students.
Thank you.
Can I ask, I thought that the Chief Justice was asking a different question, so I'm going to, what if the school says, well, I think we're going to need 2 tons of peanut butter this semester, and says to Sodexo, let's go with 2 tons of peanut butter, and then they only sell 1.5 tons of peanut butter. Does CSM have to pay Sodexo for 2 tons of peanut butter or 1.5 tons of peanut butter?
So the pricing is not, as you I'm sure are aware, is not sort of based on the individual ingredients. It's based upon the amount of students that are enrolled in the meal plan program. So that's why the school has an obligation to pay Sodexo based on all the students who are listed as being part of the meal plan program, whether or not each of those students has actually paid the school what it's obligated to pay the school. So I'm not sure I'm being fully responsive, but the way the contract works, the school doesn't actually get involved in how many tons of peanut butter. It does play a significant role in determining quality of the food, parameters of what's going to be provided. It has a lot of input into that process. It doesn't actually make the decisions about how much of each ingredient to buy.
Okay.
Right, because as Justice Gabriel asked, it's in the nature of a requirements contract. The school says to Sodexo, we have 100 students enrolled in the meal plan this semester, and it leaves it to Sodexo's expertise to determine how many pounds of peanut butter are needed to serve that many students.
Mr. Pomerantz, can I ask it a different way? Using your 100-person example, let's say, and this would never happen at the School of Mines, but they have a ditch day. And nobody shows up for school that day, nobody comes in and eats. Who loses money that day, Sodexo or School of Mines?
Well, I suspect neither party loses money because...
Well, you've got meals prepared for whatever. You average, say you made meals thinking 100 kids were coming.
I think the best way to answer that is that the students lose money because they're obligated to pay the amount. In fact, they've already paid the amount at the beginning of the semester for the meals, whether they eat them or not. And the school, in turn, pays Sodexo based upon the students that are enrolled at any particular time. It's not based on how many students actually came in to collect a meal on a given day.
So you'd be paid for 100 meals regardless of whether 20 kids came in or 100 kids came in?
Sodexo is paid for the 100 meals. Now, the school may not be paid for the 100 meals Because if a student is delinquent on its account, hasn't paid, if they decide to provide a refund to a given student, the school may not actually receive money for that meal. In the most typical situation, though, they would.
So just to be clear, if the student buys a 100-meal plan for the semester, it pays that money to Mines, and Mines pays Sodexo for the full 100 meals, whether the student swipes the card 100 times or only 20 times?
That's correct. That's correct. Now, they're very different prices, obviously. The school
Right,
collects...
but the payment to Sodexo is based on the assumption that the student would actually use up the full 100, not based on the actual number of meals swiped on the blaster card.
You know, I think that's right. I'm sure there are calculations that are made by Sodexo based upon its experience to determine how many of the students that are enrolled in the meal plan in any given day are actually going to come in and take a meal.
So I'm in the Court of Appeals decision, which is just the closest thing I could reach to for the decision says periodically Mines reports the number of meals used under each of its meal plans to Sodexo. Sodexo then invoices Mines based on that report.
Right. I don't know that's exactly accurate. I believe the way it works is that CSM invoices Sodexo based upon the number of students that are enrolled in the meal plan in any given week. And that's the basis for determining how much they have to pay Sodexo. So
it's not the number of meals used, it's the number of meals that should have been used based on the number of students enrolled? Because those are two really different things.
I'm not quite sure exactly. I'm not sure I see the difference. It's the number of meals that are anticipated to be used is based upon, obviously, the number of students that are enrolled. On a day-to-day basis, obviously, there can be a difference between those two numbers. The number of students enrolled is used as the proxy to determine how many meals are actually being provided, first from Sodexo to CSM, and then from essentially what's been sold by CSM to the students.
Okay.
I want to make sure I'm being responsive. So Justice Hart, if I'm not fully understanding the question, I'd certainly like the opportunity.
I guess, Mr. Pomerantz, can you direct us to a factual finding with regard to that? Because if you're saying the Court of Appeals is wrong, to me, it's a significant thing as to whether it's wholesale or retail, depending on who would lose the money for that day, depending on whether it's based on enrollment in the program or whether it's based on meals actually consumed or swiped.
Right. The reason why the university stands to lose, or the circumstances under which they can lose, is they have to pay Sodexo based upon who's enrolled, right? And that's true whether or not every enrolled student has actually paid them. So there might be 100 students that are enrolled and reported to Sodexo as being enrolled in the program, for whom Sodexo has to make sure meals are provided and available. But the university may not have collected funds from 100 students.
Well, I don't want to get into speculation about that. I mean, the bottom line is, does Sodexo make money based on the kids that are enrolled or based on the number of meals that they use their blaster card?
It's determined based upon the number of students that are enrolled.
Okay, thank you.
But can I just follow up, come back to where I started? So if I'm understanding your answer, the risk that the school may have is the risk of default by the student who's agreed to buy this. But they don't have any risk of being unable to sell at retail everything they've purchased at wholesale under your use of the labels.
But they do, and I want to make sure I'm the answer. They are paying for all of the meals that need to be provided to 100 enrolled students. Whether or not the student takes the meal and whether or not the student pays for the meal. So they do bear the risk of meals that are provided but that they never receive compensation for.
What does it mean to be enrolled? I take it that's a contractual arrangement, and then the purchaser of what you would call the retail of the meal has agreed to buy that before the school agrees to purchase it in wholesale.
That's true. And yet there are a number of situations, as I understand it, where a student doesn't pay on time, is delinquent, for whatever reason, doesn't honor its full financial obligations under the residence hall contract. And the university, as you might imagine, is in the position of trying to determine whether or not that meal should be provided nonetheless. And it is not uncommon that they decide to allow that student to collect the meal, even though the student is late or in some other way delinquent on the payment for that meal plan, because they want to make sure that the student is fed.
But sort of, if I can remember it, going back to Justice Marcus's example, they never have a situation, though, in which they've purchased an amount of X amount of peanut butter at wholesale and are unable to sell that at retail. The contract is arranged in such a way as they only receive as much peanut butter as they've already contracted to sell at retail.
As they've contracted to sell.
Right.
As they've actually sold,
Right.
the
So
answer
if
could be
there's
different.
slippage, it's that somebody's defaulted on the school, right?
That's the slippage, yes.
Okay.
Right.
And the issue would be, and I think I'm tracking with you, I want to make sure. Sodexo is not at any risk here. It sells 100, it agrees it's 100 meal plans, it's going to get paid for 100 meal plans. Now, I think what you're saying is the student may not pay the School of Mines for whatever reason, financial issue, whatever else. Sodexo still gets paid, but the School of Mines may not have gotten paid.
That's true. And
So the risk is on the school.
The risk is on the school, yes. Right. Now, the risk, Sodexo bears risks of not being able to provide the meals in a way that allows them to earn a profit, right? They're limited, their compensation is limited based upon enrollment. They get a fixed amount. If food prices go up, they bear that risk, they bear that loss. If they don't calculate properly and they overestimate the amount of food that's going to be eaten by the 100 enrolled students, they could lose money. If they fail to honor any of the terms of their contract with CSM and they're in breach in some fashion, they may have some financial obligation to the university. For example, if the university decides to reject any of the meals or contents of any of the meals. So there's certainly risks, and there's risks of loss, but there's an understanding as to the amount they're going to receive, and that's the sole amount that they're going to receive from the university.
And so to the extent the Sodexo is at risk, it may have miscalculated the price it charged because food prices went up or whatever else. That's where its risks lay, not in what happens with a student.
I think that's correct. Yeah, I don't think this is terribly different from any other type of requirements contract, where you have a retailer that goes out and it finds its audience, it finds its customers, it makes commitments to those customers, and it says to a wholesaler, I need you to help me satisfy my requirements, to fulfill my obligation to my customer, and that third party comes in and does it. That third party isn't going to bear the risk, that wholesaler isn't going to bear the risk that the ultimate consumer, the retail customer, reneges on the obligation. But nonetheless, there's two transactions there.
When does the retail transaction here happen? Is it when the student buys the meal plan or some other time?
When the student buys the meal plan. Because at that point, the promises have been made by each party, the commitments have been made, and the consideration has been exchanged, right? So that's enough to create a sale. The wholesale sale takes place when consideration is paid on a monthly basis for the meals that are provided to the students that are enrolled in that particular month, right? So, and I think it's important to note you've got two different contracts that provide for two different streams of payment in two very different amounts. Streams of payment are handled very differently. School of Mines collects its funds. It does with them as it sees fit. It puts those monies into its own accounts. It commingles those funds with other funds that it collects from students and otherwise. And those funds are very separate from the funds that it will later pay, again, on a monthly basis, to Sodexo with money that is allotted to this particular purpose by the state.
Mr. Pomeranz, am I correct that Sodexo has no decision in how much School of Mines sells the meal per meal plan?
That's absolutely right. They have, not only do they have no say in how much is charged to the students for the meals, but they have no say in any aspect of that contract. They have no say in the amount, obviously, which is substantially different than they get paid. They have no say in the timing of the payment that is made by the student. They have no say in whether a particular student is eligible for the program or not, or whether a refund should be given, maybe because the student is going to be sick for a period of time or has to go home for a period of time. None of the contractual obligations and duties between the school and the students, Sodexo has nothing to do with any of those. All it does is it shows up and it fulfills its obligations under its contract with the school to provide meals and to make them available.
May I ask you to shift to the issue of the fact that this is an exemption and how that changes the burden?
Right. So I think the question of what standard of construction applies to exemption statutes is relevant in situations where you have a statute that's ambiguous. So I think the first task for the court always, and certainly with respect to exemption statutes, is to determine the meaning of the exemption and to first ask whether there's any ambiguity in the statutes. Here, there's no ambiguity with respect to the fact that the city, like every other taxing jurisdiction, has an exemption for wholesale sales. And I don't think there's any ambiguity with respect to the scope of that exemption or any of the relevant definitions that comprise that exemption. So there is an exemption, and we know what it is. It's a sale to a retailer for resale. Neither party has ever argued that any of the provisions are ambiguous. Neither of the lower courts have found that the statutory language here is ambiguous. The aids in construction, including such questions of whether or not how doubts should be construed in favor of one party or another, we believe those come into play when there is found to be some ambiguity in the statutory scheme, and those help determine how you're going to interpret the statute, how broadly you're going to interpret the statute. I don't think any of those tools of construction should come into play here because I don't think there's any ambiguity in the statutory scheme. I think in particular, it's clear there's a wholesale sale exemption that includes sales to a retailer for resale. The key element of that exemption is what is a sale? Are there two sales or just one sale? I think it's very plain that there's two sales here because a sale, Mr. Munch sort of referenced just the first introductory language in the definition of sale, which refers to the acquisition of property. But in fact, if you go just a little bit further down in that definition, it tells you what an acquisition of property includes, and it says it includes a transfer of title or possession or both. So you need only have a transfer of title. Possession as well will suffice to create a taxable sale. I think we absolutely do have two sales here. Among other reasons, because there's a transfer of title of the meals first from Sodexo to CSM. The language of the state contract is absolutely clear that the School of Mines, that the meals become the sole property, that's the language, the sole property of the School of Mines. The title that's conferred in CSM is evidenced by a number of other factors that have already been brought out today. Their right to inspect, their right to accept or reject. Critically, the school's right to dictate which students Sodexo may serve meals to, and also to tell Sodexo which students it may not serve meals to. It has those rights because it owns those meals. It has title to those meals. I think it also has possession of those meals in various different constructs, although I know my time is limited. Justice Boatwright, I want to just add one more point to answer your question about the standards. I think once we determine what the statutory language means, and I think the statutory language is clear, then it becomes a question of whether or not the taxpayer has proven the facts to show that it fits within that exemption. And under this court's investment hotel properties case, and under the statutes that we've cited in our brief, particularly 3921-105 and another statute in Title 13 that it references, tax cases are handled in the same manner as other civil cases, and the burden of proof on facts is preponderance of the evidence. And we think we met that burden.
Thank you.
I realize my time is up. Thank you very much.
Very much. I think you've still got about 5 minutes, or almost 6.
I believe at 5:57, it looks like, Your Honor. Your Honor, if I may first address the matter of the burden of proof here. I do think it's pretty clear. It isn't a matter of ambiguity that's not required under any of the cases I'm familiar with. Instead, it's titled as a presumption. It's historically been treated as a presumption that generally the presumption is in favor of the taxpayer and against the taxing authority, but in the exception where they are claiming an exemption, the responsibility is on the taxpayer to prove entitlement to that exemption. I don't believe that were this a matter where there wasn't an exemption and the city was simply saying it needs to be taxed, that Sodexo would be giving up that. That said, I do think all the information is in front of the court. And one thing that might be helpful in resolving, whether this is done by invoice or how often, we can consult what Sodexo wrote on page 7 of their brief describing the situation, which is each week, Colorado School of Mines provides a report to Sodexo listing the number of students participating in each of Colorado School of Mines' meal plans. Sodexo then invoices the Colorado School of Mines for its sales of meals to Colorado School of Mines, it says, based upon this weekly report, and CSM paid Sodexo invoices on a monthly basis subject to the availability of state funds budgeted and appropriated. That is Sodexo's own analysis of what is going on here, and if it was a situation where it was purely based on per student, there would be no need for such invoices.
So I agree with that, and the invoicing perplexes me because when I look at Exhibit B to the contract, which is on page, I don't know which number page I should give you. It's 185, or it could be 29 with the Bates number. It says, this is resident dining rates, and it says paid to Sodexo per student per day, not per meal sold to a student. So it seems like what is happening is whether if you're enrolled in a meal plan, Sodexo's getting money for you, even if you don't eat food that day, based on the language of this.
But at the same time, per your question about, there's no risk to Colorado School of Mines that they're ever going to be left with anything left over. If, as you said, you asked about, if they order 2 tons of peanut butter and are then left with 1 at the end of the day, that's Sodexo's problem, not Colorado School of Mines', which indicates that this is exactly what it says that it is. It's a contract for provision of food services. It is valuable to the Colorado School of Mines to have these franchise and these food service facilities on campus, and therefore they have negotiated a contract with Sodexo to provide those services. And everything we have here is consistent with a service contract. And there's nothing about the fact that, for instance, if a student fails to pay Colorado School of Mines, that Sodexo still gets its money. There's nothing about that that's inconsistent that you couldn't put in a service contract. There's nothing about that you couldn't put in the collection agent contract. This is exactly what it purports to be. It's titled a contract for food service. Everything in the contract refers to providing food services. It refers to the Colorado School of Mines collecting and paying Sodexo for this. It's very clear that this wholesale sale argument was only come up with after the fact to try to find a way to get out from under the sales tax that is due on them as it is on anybody else.
So since your time is short, let me just make sure I understand. I guess I'm now a little bit confused about what Golden perceives to be the taxable event. Is it the point at which the student swipes the blaster card and receives the food, or is it when Mines purchases meals from Sodexo?
Yes, the taxable event is when the student swipes their meal plan card, exchanges that balance, and then acquires, per the Golden Municipal Code, the meal in their hand.
Okay, so I understand the acquisition. That's quite obvious. What I'm struggling with is how the student is actually providing consideration to Sodexo in that transaction. Because as I understand it, the student has paid for the entire meal plan to Mines. and we're done. There's no exchange of consideration at the point of the blaster card swipe.
I don't believe that's true, Your Honor, because when they pay Colorado School of Mines, what they're doing is they're loading a certain number of meals, a certain number of credits onto that blaster card. And when that blaster card is swiped, that balance is reduced. This is the exact same thing we analogize to. We described it in our briefs, and again, I've tried to describe it here. It's the same thing you'll encounter with a gift card transaction, where you will put money on that gift card. You will load a balance, but there is no purchase at that point. There is no consideration. There is no taxable event at that point. However, regardless of how long ago you bought that gift card, regardless of who you bought that gift card from, when you swipe the gift card, you look at your receipt, you will see that sales tax is charged on that purchase made with that gift card, because that is when the consideration is exchanged. That is when the taxable transaction occurs, and it is no different here, because the consideration doesn't end up being exchanged, and the acquisition doesn't take place until that blaster card is swiped. The consideration is the reduction in the balance preloaded on the blaster card for the meal they get in their hand.
Mr. Munch, can I go ahead? If the student never buys the blaster card and never decides to use it, Sodexo still gets paid, though.
Well, Sodexo,
Because you're billing them based on the number of students enrolled in the blaster card program.
Sodexo will end up, calculating the number of meals they provided and invoicing the Colorado School of Mines for that. And therefore, the fact that, that balance might expire, or they may never get around to using their meal, is the way they manage to structure their food service contract.
Can I ask one follow-up question, Chief? But the invoiced is based not on the meals consumed, but on the blaster cards purchased, isn't it?
Again, I have no reason to believe that any of the factual statements in the Court of Appeals were wrong, and Sodexo itself says that Sodexo invoices Colorado School of Mines for its sales of meals based upon that weekly report.
Can I ask one? I promised last question. What is the weekly report? The number of swipes or the number of enrolled?
I believe they're saying the number, it's the report based on the number enrolled, but again, if it were that simple, there would be no need for invoices.
Thank you.
Thank you.
Thank you.
That card can't give you more time if you were looking. Thank you. We appreciate the arguments of both counsel. The case will stand submitted, and we're going to move right on to our next case. So we'll pause a minute and let people take their positions. All right, next case that we've got set on the dockets, People versus Anderson. Looks like you all have both been here before. You got your water, you're all set up. Petitioner, when you're ready, go ahead and begin your argument.
May it please the court, my name is Elizabeth Rohrbaugh, and I represent the people of the state of Colorado. This case granted certiorari review on the following question: whether the Court of Appeals erred in determining that the defendant's conduct, firing more than a dozen shots in the direction of the officer and his patrol car, was insufficient evidence to support the jury's verdicts finding the defendant had the requisite universal malice for attempted extreme indifference murder. Relevant considerations in this case are found in the instructions given to the jury. The jury had to find that the crime was committed under circumstances evidencing an attitude of universal malice, manifesting extreme indifference to the value of human life generally. The jury was also given a definition of universal malice, which was as follows. Universal malice means a willingness to take human life indiscriminately, without knowing or caring who the victim may be, or without having an understandable motive or provocation. Now, universal malice is not defined in Colorado statute, so that is not a statutory definition the jury was given, but it was the guidance the jury was given in deciding universal malice, and it echoes language that has been stated by this court approvingly, going back as far as Longiotti in 1909 and through cases like Jefferson in 1988 and in Candelaria in 2006. So when we look at the language, without knowing or caring who the victim may be, the Court of Appeals found that there was no universal malice here because there was only a single individual present who was the officer who the victim, the defendant, shot at. But the people's position is that the defendant's conduct here fulfilled universal malice because firing more than a dozen shots showed not knowing or caring who the victim may be. Now, in Jefferson, this court set forth a variety of factors which could constitute a sufficient degree of cold-bloodedness or aggravated recklessness to support a jury's finding that the defendant's conduct should be penalized as first-degree murder under the extreme indifference statute. 4 such factors are stated. The first, the nature, duration, and intensity of the actor's culpable state of mind, the manner of killing, the relationship to the victim or victims, and the presence or absence of mitigating factors. All of these things may affect a jury's determination of whether the extreme indifference statute fits the facts of the particular case. So all of these facts come into play. It's a totality of the circumstances test. I don't think that this court should create a bright line rule that more than one person needs to be present, that there needs to be 2 or 3 or 10 persons present. Similarly, I don't think that there's a number of shots required, right? It doesn't need to be 1 shot, 3 shots, or a dozen shots, but it needs to show extreme recklessness under the circumstances. Another very important consideration is the relationship to the victim or victims, because it might be very hard in a domestic situation where there is an ongoing relationship between the victim and the defendant to say that the defendant's action was taken not knowing or caring who the victim was.
Do we have those circumstances here? I guess my concern is whether we get to the same equal protection problem the legislature tried to fix. So here we have one officer, and where Mr. Anderson fires at one officer, 12 shots, hits the officer in the arm. Fortunately, nobody dies. Where's the line between an intentional act, or second-degree murder in that, or even attempted degree deliberation murder, and extreme recklessness?
Well, the difference...
Or extreme indifference, I'm sorry.
The difference, as this court determined in Jefferson, is that while an attempted second-degree murder involves knowing conduct, there's this additional element of universal malice. So universal malice is, in fact, what makes this different from second-degree murder. And the people's position is that here we have what this court called in Jefferson a legally sufficient degree of cold-bloodedness or aggravated recklessness.
And based on what, though? Is it the barrage of bullets?
Yes, the barrage of bullets, and this constitutes an extreme recklessness. Now, it's also true that although only one person was present, it could have been true that there could have been another officer in the car, there could have been a suspect in the back of the patrol car. This took place in front of Ponderosa High School. Now, it seems unlikely there would have been random high school students there at 2 a.m. on a Saturday night in August. However, there is the possibility that others might be around, particularly, as I said, other persons related to the police car, which adds to the extreme dangerousness of the behavior, this
Right, and I
barrage of
think
shots.
you're putting your finger on something that I think is important, and I think what that extreme recklessness is trying to capture, and that is exposure of other persons in the vicinity to being shot because they happen to be in the wrong place at the wrong time. And it seems that where we don't have, we have a finding here that there was no one around. It was 2 a.m. on a Saturday night in August on a darkened, empty road. And I guess I struggle with how shy of just the barrage of bullets, what are we pointing to that shows the extreme recklessness of this particular act?
The extreme recklessness of the particular act is shown by the totality of the circumstances. And the definition I read of universal malice, a willingness to take human life indiscriminately without knowing or caring who the victim may be or without having an understandable motive or provocation. That's what makes this different from second-degree murder, is this universal malice, this not knowing or caring who the victim may be.
So are you suggesting then that the defendant must know personally the victim, know who this person is?
Oh, quite the opposite, that the less the defendant knows the victim, the more likely this smells like extreme indifference murder. As I said, in a domestic situation, and I went back and I looked at, say, the Marcy case, where the defendant shot his wife in the liver in their family room, right? In that situation where there seems to have been a single shot directed at the victim with whom the defendant had a close relationship, that does not seem to fit within the situation of a willingness to take human life indiscriminately without knowing or caring who the victim may be.
And I'm sorry, I asked my question the wrong way. I guess what I meant to say is you're suggesting that because the defendant didn't know who this particular officer was, that shows a willingness to take human life indiscriminately? Because I guess I struggle with that. It was a police vehicle, a marked police vehicle, am I right? And
yes,
the person who steps out of that is presumably an officer, and there's no question that he was targeting this officer. It would seem that under your test, that almost any police shooting would meet this definition of extreme indifference murder.
Well, Your Honor, it might, depending on, of course, the totality of the circumstances, and one way in which many extreme indifference murder cases have arisen have been gang animus, where one gang shoots at another gang. And in that case, they don't know or care who the victims may be. It's the association with the rival gang. And I would say that that fits within a willingness to take human life indiscriminately.
But that also, in your sentence, involved shooting towards multiple people.
Well,
which evidences universal malice because you're shooting at, you don't care who you kill in this group, you're just shooting to hurt someone in this group.
so you're saying there's intention to shoot towards the group?
I mean, that could be it seems to me that universal malice has to mean something that gets it past the equal protection hurdle that the legislature was trying to fix, and the idea of shooting towards a group of people or towards one person, but when there are other people around, that the idea of universality, I don't care what happens to anyone in this situation, does seem to be encompassed in that. And I guess I'm having trouble seeing what else, how universal malice means something other than that.
Your Honor, as I have said, universal malice means this extreme recklessness or cold-bloodedness, which is shown by a variety of factors. So many such factors can establish extreme indifference murder. A classic is, in fact, firing into a crowd, and that's the situation that this court evaluated in the recent Montoya case, where the defendant fired into a home from which he had been ejected. So he was firing towards specific persons in that case. So that is one such situation which would satisfy universal malice, but that doesn't mean it isn't satisfied in this case. And I draw this court's attention to the Rubio case, where the defendant fired multiple shots into a parked car in a neighborhood that then ricocheted off the car and endangered people in 2 different houses, actually injuring, I believe, 2 girls in one of the houses, which resulted in 5 counts of attempted extreme indifference murder. Now, this was behavior that was directed, if you say, immediately at the car, an inanimate object. So it was not directed at a person. But the circumstances were such that it showed extreme recklessness because of endangering the other people in the houses. Okay, so that's one such situation where it's not directed at a person, but persons are endangered. And the people's position is that if more than one person is endangered, if there had been a second officer in the car or a suspect in the back of the car, the defendant could be charged with and convicted of 2 counts of attempted extreme indifference because he endangered more than one person. But it's the people's position that it would be an absurd result that if there were 2 persons present, which is a factor, of course, the defendant has no control over, he controls his behavior, but the totality of the circumstances is an objective matter. So if, in fact, there were 2 or more persons present, he could be convicted of 2 or more counts of attempted extreme indifference murder. But under the Court of Appeals rationale, because there was only a single officer present, he can be convicted of 0 counts of attempted extreme indifference murder.
Can I interrupt you and ask a question about, I'm getting a little confused about where you're going with the multiple people and one person. Are you saying in this case there was sufficient evidence only because of the possibility that someone else could have been present, whether or not they were, or because the defendant didn't know or care whether he killed the officer who clearly was present?
Your Honor, my position is really the second, that his behavior under the circumstances presented here constitutes a sufficient degree of cold-bloodedness or aggravated recklessness to support universal malice. Yeah. So it's true that under the circumstances as they arose, there was only one officer present. But the people's position is that that still showed a degree of extreme recklessness. And if there had been more persons present, the defendant could have been charged with multiple counts. I'm just saying that it seems absurd that if there is only one person present, you get 0 counts. But if there are 3 people present, you get 3 counts.
And maybe I could follow that up just a little. So going back kind of to where you were discussing with Justice Marcus, what does it mean then? When would this not be extreme indifference? When would it not be universal malice? If he knew the officer by name and was trying to kill him, even though he fired many shots, would that still be reckless? Would that still be extreme indifference?
If he had a personal animus against the officer, then that would tend to mean that it wouldn't be extreme indifference murder because it's the not knowing or caring who the victim is.
Right.
So if he knows the officer, that might be a factor in which the jury would not find attempted extreme indifference murder. By the same token, if he fires only 1 shot, that might not be extremely reckless behavior under the circumstances.
So I guess where I'm sort of going is where do you draw the line then? If he didn't know this particular officer, but he clearly knows he's an officer who is attempting to stop him, and therefore if he tries to kill that officer, is that not a purposeful, is that not attempting to kill someone that you do know, whether you know him by name or whether you have an animus against him, other than the fact that you know you're trying to stop a particular person from doing something he's doing? I mean, this is much different from shooting a skateboarder who's riding down the street, something like that.
You mean in terms of shooting a skateboarder accidentally or on purpose?
In terms of whether as the language we used, particularly in Candelaria, and talking about that not knowing or caring who the victim is, an act that demonstrates a willingness to take life without knowing or caring. How does that apply to a situation in which the shooter is attempting to stop somebody from doing something?
Your Honor, I'm not sure. If your question is, could this also be attempted first-degree murder after deliberation, that was also charged in this case, and this court said in Candelaria.
That wasn't my question. My question is, how do you decide when somebody is acting without knowing or caring?
I think that's a jury question. I mean, the jury decides under the totality of the circumstances, including the 4 circumstances this court set out in Jefferson. One of those circumstances is the manner of killing. And so, as I said, multiple shots would constitute a reckless manner, an extremely reckless manner of killing. But I think that I'm not in favor of any sort of bright line. As I said, I think it would be much harder to convince a jury if you have, say, a domestic killing in a home that this constitutes attempted or extreme indifference murder. By the same token, as I said, if there's an animus with a particular officer, then it might be much more difficult to prove to a jury that this constituted attempted extreme indifference murder.
What if there's just animus against the police generally?
Well, Your Honor, as I said...
And therefore I'm targeting an officer.
Well, I'm not sure what we mean by targeting.
Well,
right, because the defendant's position at trial was that he acted recklessly, not that he targeted the officer, but that he engaged in reckless conduct. That was the defendant's theory of the case.
But there's no question that the only person who stepped out of the car was an officer, and the barrage of bullets was aimed at that officer.
That's true.
Okay.
But nonetheless, that can show extreme indifference under the circumstances. I mean, it shows extreme recklessness. And as I was saying earlier, I think it's showing an animus towards a class of people, like I hate Crips for a gangbanger. I hate the police. If, in fact, under the totality of the circumstances, it's I hate this person because of the uniform he's wearing, I think that still shows extreme indifference to the value of human life without knowing or caring who the victim may be.
How is that without knowing or caring? I guess I haven't heard an answer to Chief's question or Justice Marcus's question, and I have the same question. I hate all Crips. You're a Crip. I'm going to shoot you. That doesn't seem like an extreme reckless situation. That's knowingly and intentionally trying to shoot this person because you're a Crip. Or I hate all police officers, and I'm going to fire at you because you're a police officer. What is the line in that situation between knowing or intent and extreme recklessness?
The totality of the circumstances. And I think the situation you've described was the one in the Atkins case, where the defendant approached a gang member, addressed him by his gang affiliation, and then shot him once in the chest. I would say that that would be much closer to after deliberation murder than extreme indifference murder, because it is one shot at the chest of the intended victim.
But you would say in any case, I mean, it's both? I mean, so what would he give me the definition of extreme recklessness in there? 3 feet away, I shot you in the chest.
I'm not arguing that. I'm saying that that would be closer, in fact, and you would have a difficult time, or I might have a difficult time, convincing a jury that that is attempted extreme indifference murder. Because, as I said, it smells much more like after deliberation murder because of the fact that they're very close and there's only one shot fired.
But why is that a jury question? Why isn't it just, as a matter of law, this was not a situation of not knowing or indiscriminate. You knew and you shot at that person.
Well, if we look at the circumstance, are we talking then about the gang, or are we talking about the circumstances in this case?
The example you gave me, and then we can talk about this case.
As I said, in that case, I don't know. Perhaps it would be a situation where the jury should find, as I said, that the defendant is not engaging in
But my
conduct.
question is, why is it that even get to a jury? It strikes me that's pretty arguable as a matter of law. That's not a situation where we have a not knowing. That's your definition of universal malice, not knowing and not
Or
caring.
Well, that's part of the definition. That's the one. The definition is a willingness to take human life indiscriminately without knowing or caring who the victim may be, or without having an understandable motive or provocation. So I have myself been focusing on this language about not knowing or caring who the victim may be, because I think that's definitely the situation in the present case. He did not know or care who the deputy was, beyond the fact that he was, in fact, a deputy.
But didn't he? Back to the chief's question. This officer's trying, the evidence showed this was an attempted suicide by police officer. That's what it showed. This guy knew exactly who this police officer was. He knew this police officer was trying to stop him. He's shooting at this police officer with the intent that the police officer fires back. How was that a not knowing or caring? He knew exactly what he was doing. He knew who he was shooting at. He didn't have to know his name or badge number. He knew the exact person he was firing at. How do we have a not knowing or caring in this situation?
Your Honor, if he knew the officer's name and badge number, then I would
I
say
said we
that
don't
he
have
knew
that.
him. But
Right.
not knowing or caring, I think, can be used much more broadly than perhaps you feel it should be used.
But he knew, and I'm just playing devil's advocate with you, I'm trying to figure out the line. He knew that this officer's trying to stop him, in the chief's hypothetical. I'm going to get in, this officer right here is trying to stop me from what I'm trying to get away or whatever I'm trying to do. I'm firing at him.
And
How does that fit your definition?
That shows a willingness to take human life indiscriminately without knowing or caring who the victim may be. You're saying, I believe, that he cares who the victim is because he cares that the victim is a police officer. But I don't think that's all there is to knowing or caring who the victim may be. And again, if we look at the factors set forth in Jefferson, the relationship to the victim is one of the factors which define extreme indifference murder. I'd like to save the rest of my time for rebuttal, if that's possible.
Could I just ask a quick question before you sit down? And that is, what are you ultimately asking us to hold? The third question that we took focuses on the 12 shots, and you've already acknowledged that 12 shots alone is not dispositive. So I gather that ultimately what you're asking us to do is to say that the evidence was sufficient on these facts and you don't need two people.
Yes.
Are you looking for anything more than that at the end of the day?
Well, I think it might be useful if this court thought about a definition of universal malice. Because,
Beyond
as
what
I
we've
said,
already said in Candelaria and
Right. That we have language in Candelaria and other cases that says what universal malice is. But defense counsel has said in her brief, and I expect she will now stand up and say, that universal malice is animus against humanity as a whole. And I think that universal malice has a broader definition, which is the one I've read to you.
Okay, thank you.
It please the court. My name is Liz Porter Merrill. My attorney registration number is 38447, and I appear today on behalf of the respondent, Mr. Richard Anderson. To directly answer the issue upon which certiorari was granted, the Court of Appeals correctly determined insufficient evidence supported Mr. Anderson's attempted extreme indifference murder conviction because there was no proof of universal malice. Universal malice is malice against humanity. It's malice directed at human life generally, and it is not directed at a particular person, which distinguishes it from second-degree murder. This is true for at least 5 reasons. First, existing Colorado Supreme Court precedent on universal malice. Basically, this court is not, it's not a blank slate that we're working off of right now. There are several important decisions from this court that are on point and support the conclusion that universal malice is malice directed at human life generally. Notably, Jefferson interpreted the circumstances element that's at issue today the same exact language that is at issue today. Here we're referring to it as universal malice, and in Jefferson we talked about it as extreme as extreme recklessness. And Jefferson said, it holds killing conduct not directed against a particular person at all is, killing conduct not directed against a particular person is not universal malice. Did I say that correctly?
No.
Let me do the opposite. So the circumstances element is, for universal malice, must be killing conduct that is not directed at a particular person at all.
So what do you do with Candelaria? Didn't Candelaria limit that, specifically address that, I think, exact statement in Jefferson?
So Candelaria, the holding in Candelaria is about whether or not an attempted, extreme indifference murder and first-degree murder after deliberation are inconsistent, and the court held no. So the holding of Candelaria is specific to that. The discussion in Candelaria has pieces that may draw into question this, as you alluded to. But overall, as a whole, Candelaria's language is very clear. In fact, there's language in Candelaria that specifically addresses this circumstance. It says, in the application of the facts on, page 183, there was also evidence in this case in Candelaria that they fired numerous shots in the direction of his vehicle, aware that other people whom they did not know or have grievances against were present in or around the vehicle. And so Candelaria it agrees with this statement that universal malice is malice directed at human life generally. It's not malice directed at a single individual.
Didn't Candelaria also said that the statute necessarily includes killing acts that put at grave risk a number of individuals that are not targeted by the defendant, but also acts that put at risk a single victim?
Yes, yes, you're right. You're quoting from Candelaria. So Candelaria is, I think, it sows a little bit of confusion into this whole thing, because Jefferson very clearly addressed this element that we're talking about today, the circumstances element of the three. If we break extreme indifference murder down into conduct, circumstances, and result, the circumstances element in its entirety, the exact language we're talking about today, has already been interpreted, the version of the statute at issue in Jefferson. And that was the holding that started this conversation, right? And then in addition to that, Jefferson refers to Russell, which Russell was under a previous version of the statute, but Russell likewise interpreted this circumstances element as requiring, so if you break the circumstances element into two parts, so the first part being being under circumstances evidencing an attitude of universal malice, and then the second part being extreme indifference to the value of human life generally. So both of those parts were interpreted in Jefferson. Now, the second part of that was interpreted in Russell. And in Russell, they said extreme indifference to the value of human life, by definition, does not address itself to the life of the victim, but to human life generally.
So could I have a situation, I just hate all people.
Yeah.
I hate humanity, and I'm going to shoot the first thing that moves.
Yeah.
And I aim at, there's only one person in the vicinity, I aim at that person, I kill him. Would that be extreme indifference murder?
I do not think that that is the intention in Colorado, but if this court wishes to expand universal malice to include that, of course this court may do that. But
why do you not think it would be? I mean, you take in the hypothetical, I hate all humanity, and I'm going to kill anything that moves because, people are horrible.
Maybe I spoke too soon. I suppose the indiscriminate nature of it could lend itself to universal malice. When I answered originally, I was thinking in terms of Judge Rothenberg's distinction about the endangerment of multiple people. But the indiscriminate nature, sure, I think that fits within Colorado's definition of universal malice. The problem with universal malice is, as this court has already recognized, that where do we draw this distinction between second-degree murder and universal malice, right? And And whenever we've sort of recognized problems with these two statutes, the court, this court in particular, has come back and said, well, in this case, we intended to limit universal malice to these circumstances. When we evaluated in this, we limited it. It was all about trying to limit this offense. So that's why I think I too hastily said, following Judge Rothenberg's rule, that there was no one else endangered. So, but
Could I pick up?
absolutely.
Because this may be the important point in the way we phrased the question. With regard to Judge Rothenberg's position, she flatly says that we've held that the conduct nonetheless, even though it's aimed at a particular victim, nonetheless must endanger more than one person. That seems to have been the basis of the Court of Appeals opinion. Now, are you agreeing that you think that went too far?
I am not agreeing that I think that went too far. I think it depends on what this court wants to interpret universal malice.
So you think we have said that universal malice must mean you must endanger more than one person?
Yes, I do.
Well, can I just stop and ask you then a couple of things in sequence?
Sure. Can I tell you the case that says that first, so that we're... Okay,
Sure,
go ahead. Sorry.
sure, go ahead. Tell me the case that says that.
You're in control.
Okay. You seem to have dropped back to Jefferson and picked out language from that, and even further back to Russell. And yet, both of those cases, were they not the subject of explanation in Candelaria? And did not Candelaria explain them in such a way as to say it could apply, universal malice could apply to both the situation in which you endanger many, or you simply kill the one without knowing or caring or having a reason for doing so, if that evidences your lack of value with regard to human life. My point, I'm trying to sort of narrow us down here.
Okay.
Since we seem to have said expressly in Candelaria the opposite of what Judge Rothenberg said, where I want you to go is, are you saying that language in Candelaria is somehow not stare decisis, or that it failed to contradict or overturn or explain earlier cases? How do you merge those two together?
Yeah, how do I reconcile this? Okay, well, first, so Long and Audie says that universal malice must endanger more than one life. So that's that common...
And Longinati is explained in Candelaria.
Correct, yeah,
okay.
yeah. So Candelaria talks about Long and Audie, it talks about Jefferson, it talks about Russell, very thorough, comprehensive discussion of the Colorado Supreme Court's precedent regarding universal malice and this depraved heart murder offense. How do we reconcile this language in Candelaria that seems to create a new rule, two types of extreme indifference murder, with the existing precedent, the precedent that predated Candelaria that suggested it was there was only one type of extreme indifference murder. I think that language in Candelaria is not relevant to the holding, and so if we look at the narrow holding in Candelaria, and then that language I read to either Justice Gabriel or Justice Zamora, I apologize.
We look alike.
Yeah. I was going to say,
we're on the same side of the room.
We sound alike, too.
Candelaria very clearly says that the circumstances of Anderson are, it doesn't say Anderson, but the circumstances of universal malice are that you're aware of other people whom are endangered. So that language...
Does it say both? Does it say the statute, universal malice, covers both situations? One in which you endanger others and one in which you don't?
Yes, I think the elephant in the room, you authored Candelaria. So yes, I think that...
And I guess where I'm trying to go with you is, are you suggesting or thinking that Candelaria says something different, or are you saying that part of Candelaria is not binding and therefore we should follow what the Court of Appeals has done now, which seems to fly in the face of language from Candelaria?
Well, I don't think that language in Candelaria is binding on this court because of the pre-existing precedent in this court, in this state. from Colorado Supreme Court. But if we're going to go down the road of that rule that was developed in Candelaria that did not actually apply to the holding and the facts in Candelaria, that's absolutely fine. That does not actually change the outcome in this case. Perhaps the court would want to issue a decision disagreeing with Judge Rothenberg's position, but still, if the rule is as I think you're suggesting it should be, hold on one second.
Actually, I'm just trying to sort of move
That,
you more rapidly in the direction
sorry.
of the distinction.
Yeah,
Okay.
no, I want to have this conversation, right? So I think what you're saying is Candelaria proposes a rule that extreme indifference murder occurs in two circumstances. One is when you endanger multiple people, and the second being endangering only one person's life, but indiscriminately, and that kind of goes back to what Justice Gabriel was asking. Sure, that's fine, but we still don't have that in Anderson. Mr. Anderson's conduct was not indiscriminate. He was targeting the police officer who pulled him over, frankly, in an attempt to draw fire from the police officer to kill him himself, for the officer to kill him. So under this Candelaria rule, as you're sort of referring to it, we're still in a situation where there's insufficient evidence of universal malice in Mr. Anderson's case.
Can I ask, give a factual scenario? Would you agree with me that if someone did a drive-by shooting on a house, fired 4 or 5 shots into a house, and there were 2 people in there, there could be 2 counts for extreme indifference murder?
No, I actually don't agree with that. That was not one of the issues that's not the issue before this court, the unit of prosecution.
I'm trying to find out
No,
where
absolutely.
why is that not extreme attempted, whether they did or didn't? I mean, why is that not extreme indifference?
So I think going back to Candelaria, or at least how I'm reading Candelaria, the unit of prosecution is the nature and circumstances of the killing conduct. And so I think there is at one count of attempted extreme indifference murder in that circumstance, but...
Why one count? If there are 2 people
because
in
it's
the
the
house.
whole nature and circumstances of the killing conduct.
So if there's 30 people, it's 1 count.
Correct, but that you don't have to reach that decision in this case. That's for another day.
I was just trying to get a
Yeah.
foundation of where we are. But the second question I have is, in this case, it seems to me that the jury believed Mr. Anderson's testimony that he was just firing in the direction recklessly to try and draw fire. That's why they acquitted him of the after deliberation, correct?
After doing this job for 10 years, I have no idea what juries think.
Well, but my point is
yes,
that he basically is admitting to committing something that is extremely reckless by firing 12 shots in the direction of a person and gaining the benefit of that testimony and now saying, oops, you can't convict him of this because it was only one person.
Well, I guess...
By firing 12 shots in the direction of somebody, is that not exhibiting a pretty extreme indifference as to whether you hit them or not?
I think that's intentional murder after deliberation. I don't know why the jury acquitted him of that conduct or that offense, but
if his testimony was, I wasn't trying to kill him, I was just shooting in the direction, and the jury bought that, why are we not, as Justice Hood talked about, looking at a sufficiency of the evidence question here?
I apologize, I'm not drawing the connection to Justice Hood's question from earlier, but sure, I mean, that could be reckless manslaughter, there's a number of different homicide levels that could be. Extreme indifference murder? No, because we have very clearly defined universal malice as malice against human life generally. There was no other human being endangered. This was not indiscriminate.
But isn't human life the mens rea and not necessarily the number of people that are there? I don't care whether I hit him or not. I'm just shooting in his direction.
So the mens rea is knowingly, and there was some confusion, I think, about whether or not it was an aggravated recklessness or extreme recklessness. But that was cleared up I would say in Candelaria, that it is knowingly, and that the aggravated recklessness is really the circumstances element, and I'm not answering your question, I can tell. So can you try asking me again so I can try again?
You actually answered it. Thank you.
Oh, okay. Great. So one thing that the state brought up is that this barrage of 13 bullets was essentially so indifferent to humanity that it should be deemed universal malice. I'm not very good at verbatim, but you guys understand the idea of what I was trying to say. So atrocious murder is not universal malice, and that was discussed in Long and Naughty and has been upheld throughout with the distinction between second-degree murder and first-degree murder. It's not how horrible the murder was committed that is about whether or not this is universal malice. It is the nature and circumstances surrounding the killing conduct.
And isn't the barrage of bullets part of that inquiry?
Yes, but there are other parts of that inquiry, like the fact that there was no one else around. All of the bullets were directed at the driver's side of the police car.
Okay, so
yeah.
I'm trying to put my finger on a couple of different things because I feel like the target keeps moving here.
As it does with this offense.
I thought I heard you essentially agree that using Justice Gabriel's example, it is conceivable that you could endanger and ultimately injure a single victim, but do so with universal malice. So I hate people generally. I'm going to shoot the first person I see. I shoot and fire. So it seems like we've arrived at some sort of agreement that there can be a single victim and no one else otherwise endangered.
Okay.
That argument strikes me as separate from the facts of this case. And I see sort of two things going on in this case, the barrage of bullets, but I also understand you to say this wasn't indiscriminate because he knew he was targeting an officer. He might not have known who that officer was, but he was targeting a police officer.
Correct.
And therefore, for that reason, it doesn't meet the overarching definition of extreme indifference murder. So how have I sufficiently or correctly summarized your position? I just want to make sure I'm tracking this.
Well, I think that some of the confusion is because I am arguing about what the law in Colorado generally says, and then we've sort of talked about what the rule from Candelaria is. And so I'm trying to explain answers based on both rules, and I apologize if this has gotten confusing. If we want to just stick, it seems like several of you are on board with this Candelaria rule about the indiscriminate, and in that case, there's still not sufficient evidence in this case of universal malice because Mr. Anderson was targeting a police officer.
Okay, thank you.
Yeah, I personally, it doesn't matter which rule you adopt for the purposes of Mr. Anderson's case, no matter what, there's not evidence of universal malice. But I think for the sake of clarity, for the sake of due process and notice to the citizens of Colorado, we need to develop contours for what universal malice means to adequately distinguish it from second-degree murder for equal protection purposes, et cetera. We need that delineation for guidance so people know what conduct's prescribed, so we know how these offenses work together and how they are different. And then ultimately, once we have those contours better defined, then ultimately it becomes a jury question applying those Jefferson factors. But in the first instance, it's a legal issue.
So when your opponent was up here, we were sort of batting around the language, not knowing or caring who the victim may be. What does that mean to you, and what lines would you draw around that?
Yeah, thank you for bringing that up. So I traced that back, and that language actually comes from Long and Naughty, which cites it, that language actually originally comes from an Alabama statute Alabama no longer has universal malice, depraved heart murder as first-degree murder.
Apparently no one does, but us.
Right.
Okay.
Well, we're one of a very tiny majority that has it as a completed offense. We're the only jurisdiction in the country that has an attempt. Yeah. So that language comes out of Alabama statute or case law, and then this is very next paragraph in long and naughty. It says, the court says, we should have held, without the aid of his authorities cited, that the language of the common law, basically based on the plain language of the statute. We shouldn't have even looked at these other cases, Alabama and New York. But if we are going to continue looking at this Alabama language, to take life upon slight or insufficient provocation without knowing or caring who may be the victim. What we've sort of changed that into in Candelaria is without motive or provocation. Mr. Anderson had motive in this case. He wanted to kill himself, sadly. And did he do that in the best means possible? I mean, let's not actually go there, because that's really messed up conversation, right?
But under our
mental health and other problems.
Sorry, under our case law, doesn't it have to be understandable motive or provocation? I mean, it can't just be any motive or provocation, right?
Okay, so are you suggesting that, well, it seems to me that you're suggesting that, like, wanting to kill yourself or wanting someone else to kill you is not a rational motive. And, I mean, that gets into a whole host of mental health issues and understanding depression, and I don't know that I'm qualified to really answer that. But ultimately, what I come back to is that in Candelaria, we talk about how it's about the objective circumstances of the killing conduct. And I suppose where you're going, Justice Moore, is maybe more in line with not the legal determination of the contours of this offense, but more about what the jury's considerations are for determining whether or not his conduct does satisfy the statute.
Let me go back to the language that we've been talking about, the circumstances evidencing a willingness to take human life indiscriminately without knowing or caring who the victim is.
Yeah.
I'm struggling with the concept of, if you know it's a police officer, then that's no longer a circumstance where you don't care or know who the victim is because you know he's a police officer.
Yeah.
So is that all that's needed? Is as soon as you know what they do for a living, then they basically seem to lose identity? I mean, what if you were targeting or angry at lawyers?
Yeah.
And shot a bunch of lawyers, but you knew, or shot at a lawyer that you knew was a lawyer, or bankers, or, is it what someone does for a living? Does that?
Well, I mean, I think that is, you are defining the group of people who you have animus against. That may not be rational, right? I mean, we do lots of things that are irrational. But if you have animus towards a particular type of person, I think that still demonstrates that you no longer have universal malice.
But you still don't
Singular malice is now in play.
Sorry, you still don't know who that person is specifically, right?
Right.
And you don't care. You know he's a cop, or you know he's a lawyer, or you know he's a banker, but you don't know who that person is. You don't know his name or her name, right? You don't know anything about them, and you don't care.
Yes, but we have statutes that cover murdering people you don't know, and we have statutes that cover murder of people that you do know. And we don't normally, I don't think I don't think that it matters for this calculation that there's a large swath of people that fit this category, right? I mean, in this instance, Mr. Anderson was bent on killing himself. He was trying to do so. He got the cops called on him. He fled the situation. The cops pulled him over. He then tried to shoot the officer who had pulled him over, and he succeeded in shooting him in the arm, unfortunately, but luckily did not take his life, and The officer returned fire and shot him. He twice died on the way to the hospital. They resuscitated him. He had a very strong motive in this case to die or to shoot that officer, to force that officer to shoot him. That's the circumstances of this case.
What if he'd fired at a dozen police officers with the same objective in mind?
A dozen police officers? Yeah, that's universal malice.
So I'm struggling with why there's a principal distinction there. I mean, you're saying, well, no, his purpose was just to draw fire and kill himself. So he was using the police officers generally, he's using police generally as a way to accomplish that. And so why does it matter if it's one or a dozen?
Because that's what we've defined the offense as in this state.
I thought we just went through that, though, about you don't necessarily have to endanger a bunch of people, right? It can be one.
I mean,
let me go back to my point. With the question I asked, it seems to isn't that what the killing act that the extreme indifference murder statute is aimed at, right? That someone kills, or in this case, attempts to kill another human being without knowing who that particular individual is. You don't know his name, you've never met him, and you don't care.
No, I think that offense statute criminalizes conduct or circumstances where your killing conduct it's malice towards human life generally. It's not towards a particular human's life. This was a particular human. And that's the way this court has repeatedly drawn the distinction, is saying what second-degree murder is and then saying that's not what extreme indifference murder is, this is what extreme indifference murder is. It is universal malice. It is malice against human life generally.
Why couldn't a reasonable jury in this case, and I'm really picking up Justice Hood's point, the jury seemed to conclude there wasn't intent or deliberation. Mr. Anderson was just firing indiscriminately, attempting to draw fire. Didn't care if he actually even killed this officer, just shot in his direction, put him at grave risk by firing in that direction, and he drew the fire back that he was hoping to. Why couldn't a jury say that on these facts it was indiscriminate, it was extreme recklessness, there was not intent or deliberation?
Well, so the jury also found Mr. Anderson guilty of first-degree assault and with an intentional finding there. So Mr. Anderson was also convicted of 3 counts of first-degree assault, one based on a police officer, one based on serious bodily injury, and one based on extreme indifference murder. And then this raises another issue that I raised in the Court of Appeals but was not part of the cert issue, is the equal protection challenge difference between attempted extreme indifference murder and first-degree assault based on extreme indifference murder. And I believe it was Castro that said that distinction is that you gravely harm the person is what allows you to charge attempted extreme indifference murder versus first-degree assault. And while there was SBI, serious bodily injury in this case, the officer was shot in the arm, there was testimony from the expert that he was not at serious risk of death. So that factor also lends to Mr. Anderson should be held accountable for first-degree assault, extreme indifference murder, but not this attempted extreme indifference murder offense.
Final question. What do we do with the last line of the statute that says, which creates a grave risk of death to a person or persons other than himself?
Sure. I see my time is almost up. May I answer that question?
Please.
Okay. So I'm going to turn to Jefferson. Jefferson, which again analyzed this exact circumstance element, said the 1981 edition, which includes the or persons language you just referred to, the 1981 edition of the words universal malice and generally to the language of the statute is the unmistakable indication of the legislative intent to retreat from the confusion sown by People v. Jones and the 1977 amendments and limit the application of extreme indifference murder to situations where the actor demonstrates an indifference to human life generally as distinguished from indifference to or willingness to take a particular human life. This interpretation is supported also by the addition of the words or persons. So this court has already held that or persons is just a third attempt by this legislature to really drive home that universal malice is malice against human life generally. I recognize that Candelaria said something different, so you'll have to reconcile that. But I see that my time is up, and I would ask this court to affirm the Court of Appeals decision and vacating Mr. Anderson's attempted extreme indifference murder conviction. Thank you very much.
Corby, I think you still have 6 minutes.
I'll try to use them wisely. I'd like to begin with just an observation about the trial in this case. I wanted to be clear, Justice Boatwright, that the defendant did not testify at trial, that there was some testimony about how extremely depressed he had been, but he did not testify as to a version of events.
Okay,
so
thank you.
the defense theory of the case was that he was guilty only of reckless endangerment, and this then was an inference based on the events. But we're drawing inferences about what he saw and thought at the time based on his behavior.
Thank you.
Looking at the sort of totality of our extreme indifference cases, the language of Candelaria clearly says that there are situations in which only one person is endangered that can be attempted extreme indifference murder or extreme indifference murder. And again, it's part of the totality of the circumstances. In Candelaria, there were 24 shots fired at another car that contained 4 people, and that was extreme indifference murder. Now, in the 1909 Long Giannotti case, the court said the deceased and the accused were standing on a street corner. They were quarreling and were but a few feet apart when the accused deliberately and intentionally shot and killed the deceased. There was nothing in the act of the accused that can be regarded as greatly dangerous to the lives of others. Now, in that case, you had a situation where there's a single shot and they're standing next to each other quarreling on a street corner. As I said, that's something that smells much more like after deliberation murder, given the totality of the circumstances, including the single shot.
We also had a different statute in La Giannotti. I mean,
Oh,
we keep talking
absolutely.
about it. I mean, the statute said perpetrated by any act greatly dangerous to the lives of others.
Yeah, no, it's a depraved, it was called depraved heart murder. And this court said in Candelaria that while that provides some guidance in the meaning of universal malice, it's not the same crime as the depraved heart murder.
How does attempt liability factor into all this? I know we've been talking about the underlying crime, but this was attempt. So how does that factor into all this? I mean, people tend to think of attempt as everything the underlying crime requires except the person didn't die, which is not accurate. So how do you think attempt liability factors into it?
A substantial step.
What does that mean for purposes of the extreme indifference murder statute?
It really means, I believe, a substantial step of the same extreme reckless behavior, the conduct. So the conduct is, in this case, as it would be in an attempted murder, arguably complete by the firing of the shots. I mean, once you have someone firing shots, you can't really take back the completed attempt. So I'd say this was definitely a completed attempt in shooting all of the shots. But when you say, how does this figure into the language of extreme indifference murder and an attempt to do so, it's engaging in this conduct. Again, I guess I have made several points, and perhaps some of them repeatedly, but I think this is a matter of looking at the totality of the circumstances as they are to an objective person. For that reason, I was asked whether it made a difference whether other people might be present, and that is a part of the totality of the circumstances, as I said, that there might be a police officer who was riding in the passenger seat of the car. So that's, again, within the objective circumstances of the case. I would note that the Jones case, in interpreting the person or persons language, said that the person or person's language meant that only one person could be targeted. Now, Jones was later disapproved of. It was a sort of quasi-domestic killing, and it didn't require universal malice. Universal malice, as we've talked about today, requires this extremely reckless behavior. And I think, particularly when we're talking about targeting a group of individuals, if you say, I hate lawyers, so I'm going to go to a bar assembly and shoot as many as I can, those people are being targeted because they are lawyers. But if you're opening up into a room of them, you are committing an act of extreme recklessness. And I disagree with counsel. I believe that you should be liable for account for every person you have endangered. So here the defendant is guilty of one count of attempted extreme indifference murder for endangering the one officer. But if, in fact, he had endangered 3 officers, he would be guilty of 3 counts of attempted extreme indifference murder. I thank the court for this time and attention, and I ask you to reverse the Court of Appeals. The Court of Appeals' decision that more than one person must be endangered is not consistent with Colorado statute or this court's Candelaria opinion.
Thank you very much. Appreciate the arguments of both counsel. The case will stand submitted and the court will be in recess.
Court is adjourned.